Motions, please hand over the slip.
These are motion.
To be mentioned for non-prosecution.
These are motion matter 187 of your lordship's list matter for upgradation matter
187
of this today's list matter.
Yes, what is the urgency?
Urgency that this is a proceeding has been initiated against unauthorized occupants. This is in respect to land. Now, we have tried to make out what is the basis of which documents they are proceeding.
Yes.
They could not. Every day, the officers are visiting. Today, this is my land. I cannot even sell or anything in respect to that land. This matter may be disposed of.
All right, hand over the slip.
Lordship mentioning for non-prosecution.
Hearing, my lord.
Hand over the slip. Have you mentioned non-prosecution?
No.
Please mention there.
Yes, I have mentioned there.
My lord,
Hearing inclusion.
Hearing, please wait. Yes.
item number 31. My lord, interim order expiring on tomorrow. Kindly.
Hand over the slip. Mention when it is expiring.
Okay.
Hearing for
Lord,
inclusion.
I'm very sorry.
Hearing for inclusion.
Hearing, please wait.
I'm very sorry to disturb my lord. My lord, I am disturbing your lordship repeatedly. With regard to item 51 and 52, this is with regard to my lord.
What do you want?
My lord, lordship, kindly hear out the matter
Yes,
too.
hand over the slip.
Tomorrow, my lord.
All right, let me see.
Well,
Yes.
Milord, one matter wrongly appeared in the corporation. Release then after rectify the presentation form, it will be before your lordship.
Hand over the slip.
This pertains to the review application which my lord was sitting along with us to put in hot charge. Well, we are supposed to hand over the written notes. Well, both parties are here. Mr. Ghosh's mother expired.
1 week, Mr. Bordon.
I mentioned.
Given another 1 week's time.
I'll tell you.
And now,
Let me indicate. I came and mentioned and sought for 1 week's time. Your lordship was pleased to indicate that we should serve it together. My advocate and record wrote to them saying that this has been the pleasure of your lordship. Now they are ready today. They have given us notice, and we are here, my lord. Ours was ready quite some time back, my lord. No, we're serving 1 copy and 1 copy will it's division bench, so it's 1 copy we'll serving today. We'll serve both the copies. Hand over both the copies today.
why 2 copies?
Division bench.
Oh,
The other one will handle that bench officer.
yes. Hand over 1 copy here. Yes.
I'm grateful, my lord.
Yes, Mr. Mukherjee. Oita. Yes, call the list.
My lord, as this matter, my lord, appeared on the previous occasion.
Yes.
So I was before your lordship praying for, my lord, withdrawal of this writ petition due to amendment of the cost title, which is not possible at this stage. So I am here with instruction, my lord.
I have taken a preliminary point on that day when the matter was taken up for consideration.
Yes,
because
I bow down.
I have stated something that, my lord, kindly see once, my lord, the 2 amendment in the writ petition, how the petitioner derived the title has not been mentioned. And now, my lord, he is challenging, if your lordship see the prayer, the proceeding has been initiated in the year, my lord, 1960.
What do you want? Do you want leave to withdraw with liberty to file afresh?
Yes, because my lord, the cost title is entirely different. I bow down, my lord.
Oh,
This
that
is my
one.
mistake. Yes.
What cost title, my lord, nothing has been.
Later, yes. Yes, Mr. Mukherjee. You'll be having your right to object at the time when the main matter comes. The learned advocate appearing for the petition.
The matter was mentioned as at the instance of the petitioner for appearance as to be enlisted as a to be mentioned matter.
Yes. Why, Mr. Mujumdar?
It's a notice under the Public Premises Eviction of Unauthorized Occupants Act 1971. But not there is a writ petition pending between the Kolkata Port Trust and the state of West Bengal, regarding an order passed under Section 4 of the West Bengal Estates and Forfeitures Act 2012 before a coordinate bench.
Oh, so you wanted this to be heard along
Yes,
with
sir.
that.
Where there is an interim order that for the time being, state government will not execute the order, but there is no stay on the order. So, I was wondering if this court may, I can proceed this matter before your lordship.
So what is the issue there?
Who is the owner of that land? The state of West Bengal or Kolkata Port Trust? Now, if Kolkata Port Trust is decided to be the owner, then this notice for eviction has some bearing.
Otherwise,
Otherwise, as of today, there is no stay on the order passed under the Act of 2012 by the government of West Bengal under the West Bengal Estates and Forfeitures Act. So, to whom am I required to pay the rent or who can evict me?
so according to you, that's the foundational
That's the
matter.
foundation.
If that goes,
To the root of the matter.
Mr. Mojumdar, learned advocate, appearing matter,
So, the Port Trust Authority is the principal respondent, I find, at this juncture. Let
yes.
them come.
Here state is not a party. Yes, state is
No,
a
state
party.
is the party, 4 and
But
5.
effective
No,
relief
4,
is
only
against
4.
Port Trust.
Yes.
It is effectively, it is,
You are right. Effective relief is against the
No.
Port Trust. Effective relief is not against the state.
and the state
But
is,
the question of jurisdiction will depend upon the decision in that matter. That's Mr. Mojumdar's
Yes, please
submission.
come to page 66. The cause title in the other writ petition.
66, no?
Yes. Board of Major Port
Yes,
Authority
yes.
versus the state.
So it's the subject matter of this writ petition, the property involved falls within the scope of that writ
Yes.
petition. Portion of that.
Oh, sure. That's a huge line.
Uh,
Yes, I
so he only wants that these two matters to be placed before the same bench.
very well, very well. I am not.
I understand that that matter has been assigned before the Honorable Justice. Please come to the order.
So that has been also assigned.
Yes.
কোথায় assigned হয়েছে বলতো?
So where is the Port Trust, Mr. Mojumdar?
Not we have effected service.
Who is appearing?
Normally, Mr. Jena appears. Or now, nowadays, too many lawyers appear.
Sujana
Normally
appears,
appears. Yes.
not nowadays.
In
Used
some
to
matters,
appear
yes.
long before.
Not as a standing counsel.
Yes.
But can you inform
For a
Mr.
long time.
Mojumdar? Can you come back?
Yes, yes. I can.
Because otherwise I do not know whether he has something to say. When can you come back? 12 or 1? Which
1
time?
o'clock, no, 1 o'clock.
1 o'clock will be convenient. Mr.
That's-
Commentator, if you can come or if you
Yes.
can send your junior on that. Because that's exactly what Mr. Mojumdar's submission is. that
I've got,
those two
I've got,
matters are-
I've got.
You can also go through that papers if you have something. Please come at
Lordship,
1.
Lordship, let us come back at 1 o'clock.
Actors.
Oh, Mr. Basu also appears sometimes as a counsel.
তুই appear করিস?
Port Trust করিস তো তুই?
যখন brief দেয় তখন
এটা- এটা-
করে। চাইবো
You appear for the.
Yes, engages Mr. Basu, then he can.
If you,
No, no. Let them come, let Mr. Jana decide.
Jana, Jana.
Jena. Not in all matters. I am one of the counsel in the panel. That's so many.
so can you appear
Very
in
honest.
this
No,
matter? If you can,
No, I can.
Mr. Mojumdar, who is appearing for the Port
Jena,
Trust in that
Jena.
matter?
Mr. Jena.
Order a copy.
Mr.
Jena.
জমি মানে
I think
Jena।
it will be better if you can inform Mr. Jena.
I shall inform you.
So এটা একটার সময় রাখুন। এটা একটার সময়।
Tomorrow, both Mr. Jena and Mr. Basu come at 1 o'clock. If he is not there, then he can be there.
Their
He will be
choice,
there.
Mr. Basu can come.
করবেন না স্যার, এটা ভাবে কি বলুন তো ব্রিফ চেয়েছে
Yes, call the next matter.
Milord, extension of interim order. Today is the last date, Milord.
Mr. Mujumdar, also you can do one thing, you can inform Mr. Jaina what's the subject matter so that it might be easier from him
31st
to
March. No? Aaj ko
instructions what to apply.
Milord, 31st March is the date of expiry of the interim order. Kindly fix the date.
Similar matter, my lord.
To
My lord, 3 to 7. My lord, in those matter, my lord, report was filed and they filed the
What is this
exception, my
matter,
lord.
Mr. Bose?
Milord, 62 Milord, there is a Milord, your lordship knows Milord that there was a Bengal Television and Alluvian land. A writ petition was filed under the guise of a public litigation where Milord, the Honorable Division Bench Milord, was kind enough to pass an order that those Milord who have unauthorizedly occupied Milord, the river bank Milord, without any proper authorization, the land particularly belongs to the state Milord, they Milord should be evicted upon due course of law. Accordingly, a show cause, a proceeding was initiated. Appeal was filed, Milord, in terms of the provision of the Act. And ultimately, we lost everywhere and we came before your Lordship's court. And, Milord, our main point that the invocation of Section 62 cannot be oblivious of the fact that the Shikosti land, because the Bengal Alluvian and Diluvian regulation, 1885, much before the Constitution was promulgated, Milord, was subsequently transformed, Milord, under the Panchayat Act Section 12, Milord, the law of alluvian and diluvian, Milord. Milord, we relied on a judgment. We said, Milord, that if before 56, Milord, if
What are we challenging here?
I am challenging, Milord, the initiation of the proceedings and, Milord, the decision-making process. And we said there are 2 or 3, Milord, more than 2.
This is against the appellate order. Against the appellate order.
Yes, ma'am.
So affidavits.
Everything is counted. Taito? Arjun?
All the-
Well, I am appearing for the
It has to be hard.
West Bengal Pollution Control Board. I have filed a report indicating, my lord, that in which brickfield, my lord, they have consent to establish,
Field.
yes, and consent to operate. I have indicated that.
He does not have that.
In some of the case, some of the brickfields, they do not have this.
That is not the issue here. Issue is, Milord, Milord, we must be confined, subject to with deepest respect to my learned, esteemed friend, Milord. The issue, the court is possibly confined to the issue, the parameter and the decision-making process involved in a proceeding instituted under Section 1962 Act.
What was the interim order?
Interim
What was the interim order?
interim order,
passed?
হ্যাঁ?
Maintenance
আরে
status.
interim orderটা প্রথমটা কোথায় গেল? interim order বার করতে বললাম 90 first order.
5/2023. What is the nature of the interim order?
Interim order will date give an order of status quo both the parties in respect of the possession of the plot in question till this date.
Status quo with regard to the possession. Who is in possession?
I will-
Not indicated in the order.
Millard, they're not indicated, Millard, but Millard, the eviction is
Undefined
the
order of status
Millard,
quo.
but Millard, the fact remains that the eviction indicates, admitted the state has passionately contested the proceeding, saying that the eviction from the land means I am in possession. There is no, Millard, one matter has been taken up by Justice Bhattacharya. I have, Millard, kindly. কি করবো দেখ না ওখানে কি হলো
The interim order.
into 7.
My lord, otherwise, he has no any case, my lord, in spite of that, my lord.
My lord,
he is
interim order
contracted
till
to-
But he got an interim order
Yes, my lord.
initially
Not-
passed,
not-
time to time extended. What can be done?
yes.
my lord, interim order extended till
July 8.
শ্রাবণ মাসের আগে
Yes, next.
My lord, item number 3 to 7, ma'am.
3 to 7.
3 to 7.
3 to 7, same order.
3 to 7.
Lordship, I am for the petitioner.
I appear for the private, respond number 2 and 3. SST.
Answering respondent.
Lord, basically, yes, because Lord, the main allegation is against my client.
But I think the state was supposed to file some report
Yes.
or
Lord,
Mr. Mukherjee.
Lord, there was a direction to file report by SSD, which we have filed.
Yes,
Report
but I
in the
think
form of
the
an affidavit.
state also has some role to play here.
Lord,
I do not,
the lease is between the state and Lord, the petitioner.
Yes.
And Lord, the policy of the state is, Lord, that if construction which is to be made in terms of the lease within a particular time has not been made, then Lord, they will forfeit the lease, and Lord, they will not extend the time. Here, Lord, the petitioner has transferred the land to a third party.
But the transfer was approved by the
Lord,
authority.
that is a miscommunication. I placed that letter before your lordship and also the board minutes. What, Lord, if your lordship kindly, Lord, take my
Can it be hard in the absence of the state?
Lord,
Say so, I can take it up. Otherwise,
Then Lordship kindly fixes a specific date. We shall inform the state because on the last occasion they were
they
present.
had the specific date.
No,
I
Lord.
extended it, but I
Yes.
was under the impression that I will be.
this is a very short. This is a very, very short point.
But
Lord,
state is not represented. Where is Mr. Mukherjee and Mr. Noskor?
Last day Mr. Northkar was there.
Lord, there is a minutes of the meeting which I have, Lord, annexed to my report. And
It's to your report.
yes, Lord. Kindly see page 18 of the report. This was the minutes of the meeting.
Report in the form of an affidavit by 2 and 3.
Yes. Yes. Page Lord 18, if your lordships kindly come to.
Yes.
My lord will find that this is the extract of the minutes of 144th meeting.
Yes.
Kindly, my lord, see item number 1, development of land, Prantik matters, development of Prantik township matters. This authority received fresh application for following plots and holder of Prantik township for transfer of their leasehold plot other than close blood relationship. Then, Lord, kindly see 3, item number 3, Devol Kumar Sen. And then, Lord, kindly see what was the decision. The said matter was placed in the meeting, which was approved for onwards transmission to the Urban Development and Municipal Affairs Department, Government of West Bengal, for approval.
So, according to you, you only forwarded this case.
Absolutely. Because, my lord, the lease is between the government and, my lord, the petitioner. If your lordship looks at the lease now, Lord, why unfortunately?
From which document? Because
Yes, I'll
satisfaction that that was approval.
Yes, that
Lordship, page 35 of my writ petition.
correct. Page 35.
Lordship, this was the extract of that Lordship 144th meeting which was communicated to me. And that too by Sriniketan, Shantiniketan Development Authority.
This is what the miscommunication is. Lord, what the minutes was and what is communicated are two diagonally different things. And Lord, I have explained this, Lord, in the report that I had filed. Because, Lord, the lease is between the government. If your lordship now takes the lease once, kindly see the lease, page 17 of the writ petition. Kindly see, Lord, this indenture of lease dated such and such between the governor of the state of West Bengal, represented in this case by Sriniketan Shantiniketan Development Authority, acting for and on behalf of the Urban Development TNC Department. And Lord, this is the document based on which, Lord, this lease was executed, and then, Lord, construction within 3 years, your lordships will find clause 23. Page 27.
That is not under challenge, but she said that that was the submission based on
But
that communication that was.
It was not her fault.
For transfer, that was approved.
Lord, it was not her fault because it was miscommunication, complete miscommunication. Because, Lord, the decision of the 144th meeting was forwarded to the government, and Lord, the decision of the government, your lordship.
Your role.
Lord, I am, Lord, a facilitator, so to say, because I am there. Lord, your lordships have seen, Lord, my role has been described in the lease agreement itself.
Yes, which page?
Where the first recital. Lord, your lordships kindly see first recital.
Yes.
Page 17.
Page 17.
Yes, I was, Lord, kindly see the beginning of the document.
Yes.
It says, Governor of State of West Bengal represented
by Sriniketan Shantiniketan.
Yes. But I was just a representative, Lord, for the purpose of signing. This was my role. The land belongs to the government, Lord. It doesn't belong to me. As a development authority, I am there. I was asked to sign, and that is also, Lord, on behalf of the Urban Development Department. This is my problem. And it is a fact, Lord, the communication was a miscommunication.
All right. Then what happened after this?
Lord, after this, what happened is, kindly, Lord, see the UD department's minutes, which is, Lord, at page 37.
37, yes.
This 144th minutes was forwarded. Then, Lord, this is what the government says.
Oh, but no decision on that transfer.
No specific decision. This is
That
what
was forwarded. The prayer,
Yes.
they applied that I want to transfer to person
Right.
X.
Right.
That was forwarded by 144th meeting.
Correct.
This is a decision for resumption or for such and such thing, but no decision on the transfer.
Kindly, Lord, have a look at, Lord, the 9th November document. It starts with by saying, it has been observed that large number of plots of land allotted on leasehold basis under control of the Department of Urban Development, etc., and also under different development authorities, planning authorities, including HIDCO, remains unutilized, violating the terms and conditions of the lease. The issue has been discussed at
No,
the meeting.
that is, this proceeds on the basis that there has been a violation of certain
Right.
terms and conditions of the lease.
Yes.
But the fact remains, they have applied for transfer, that can be allowed or that can be rejected. But
Lord,
that decision you have only forwarded to the authorities.
Absolutely.
They are
Absolutely.
silent on
Yes.
that, but this decision has come.
Lord, Your Lordship can direct the government to take a
That is
decision.
why I think the state was
This is the only thing which is required, because, Lord,
a decision on the transfer has to be taken. If that
There-
is not the approval, they must know the reasons. They can either challenge or they can accept that. That's up to them. But unless they know the reasons of what is the fate of the transfer application, because
Lord,
forwarding was when?
apparently, my Lord,
Well,
the
Lordship, page
resumption,
65 at 16th of September 2022.
So this is of 2022
Yes.
and
And the notification is of 2023, November
so prior to that
2023.
this transfer application was pending.
transfer application was forwarded. Your Lordships
Yes,
kindly
so
have
it
a
was pending before the authorities.
pending before the authorities. This decision came on 9th of November 2023.
Decision on transfer.
Lord, as I said, Lord, there has been no specific decision on that application. Your Lordship can always, Lord, direct the state to consider that specific application, because, as I said, Lord, we have no role to play except for forwarding, Lord, the application,
No,
which
but
was
Lordship will kindly see page
Only one
35.
thing, Mr. Court, thereafter no lease has been executed. It has not been settled in favor of any third party.
no.
So if that is so, I think the best thing is I can direct them to take a decision.
Absolutely,
On the
that can always be done. I'm not standing in the way insofar as that is concerned.
But Lordship, in my respectful submission, Lordship, even if today, Lordship, my transfer is not allowed, even then, Lordship, they cannot penalize me on based on this notification.
Chakraborty, that has to be decided once.
Because Lordship kindly sees the notification itself. It says, Lordship, the second paragraph of the notification, page 41. The issue has been discussed at the meeting of such and such, dated such and such, and it has been decided under the decision, point number 6, such and such, of the minutes that resumption process will be initiated where plots were still unutilized.
Now the resumption process has not been.
Yes, this has been initiated. That notice is at page 38.
But not yet finalized.
No.
So it might have been initiated. So this can be stayed. I can direct them to decide on your transfer application.
Because Lordship, they said that as on that day, the plots which were still not unutilized. But Lordship, at least from 2022, I had a valid reason not to construct.
That is, and you have also paid for transfer.
Yes.
One thing, if you want your transfer application to be decided, that's one thing. And if you say, no, I don't want that transfer application now to be proceeded with, I can decide as it is on the basis of that. That you have to decide. If you want the transfer application to be proceeded, that's one aspect.
Because the lease is of 1994. So it's an admitted position that no construction was made.
Because Lordship kindly sees page 35. I was
If
directed.
you want the transfer application, decision on the transfer application, I can direct that. Or if you say, no, I don't now want to proceed with the transfer.
Transfer করতে চাই? Lordship, that I have to take instruction.
Please take instructions because the state's presence might be necessary. So please take instructions. I am keeping on a day. Please inform Mr. Mukherjee, Mr. Kaur is here. So that's the only issue because
Lordship.
transfer application, they have not taken a decision. So if you insist on that, that has to be, I can direct that. If you say no, now I want to proceed with the lease as it is, I don't want to proceed with the transfer, I can decide on the basis of this whether this resumption proceedings was right or wrong, then I can decide that.
Lordship.
But then your transfer application will not be considered. Mr. Kaur. At a line at uh,
I am for the petitioner, affidavit of service.
I am for the state.
The petitioner is the owner of the plot of land.
you are for the state.
Yes.
My lord, the private estimate number 7 and 8, my lord, blocking the ingress and egress of the petitioner by PWD road is there. My lord, I have my lord, filed a representation, page 37, before the competent authority, but my lord, till date no steps has been taken.
Yes, what is the instruction?
I have not received any instruction, though the made representation has been made on that. That will be considered.
That means we have
I am for the state.
My lord, Ladit Advocate Timir Baran Shah, behalf of the petitioner, my lord, he is engaged at courtroom number 12, my lord. I am praying for not today, my lord.
yes, what is the instruction?
My lord, as per the police report, the private respondents encroached the PWD's land. My lord, second page, first paragraph. Dada.
Private respondent served.
Dada.
The
I have instruction.
petitioner claims
11, I am for the writ petition in this matter.
I am for the stay.
Pursuant to the order of this honorable court, proceeding under section 10 was initiated. The order was passed.
Respondent, sir.
Yes, my lord. Address is
Proceed.
item delivered to the address.
Yes.
My lord, page 33. My lord, your lordship kindly come to the page 33.
Yes, then what happened?
Then, my lord, no step was taken, my lord. Then kindly come to page 38, my lord.
Yes.
No steps, my lord. In spite, no appeal
What
was
no
filed.
steps taken? The order has been passed.
Order was passed, my lord. Removal consequences step was not been taken, my lord. Removal was not been done. With regard to my lord, public toilet, that is create nuisance, my lord, in front of my landed property. In front of my residential property. Residential house.
Yes, what is the instruction?
Instruction, last executive magistrate passed an order which is at page 36.
Yes.
After that, my lord, and later was issued to the officer in charge on 28th July, my lord, that is at page 38.
Yes.
And subsequently, last, my lord, 11 November, there is a communication which is at page 39. That first week of December, after that, my lord, steps taken.
Any appeal preferred?
No. No appeal preferred.
No, my instruction is no appeal.
The petitioner
12 my lord, I have appear for the petition.
Yes.
My lord, admittedly, my lord, but the 0.22 acres of petitioner's land, my lord, is under excess possession of the Tista Barrage project, my lord. But without any, my lord, the acquisition proceedings.
Admittedly.
Admitted. They have admitted.
Show the admission.
Page 9, page 20, my lord. Page 20. Last paragraph, my lord. Thus, as per joint inspection inquiry report dated 29th December 2017, in which you appear person, it is found that Tista Barrage has excess land possession of 0.22 acres, but the no acquisition proceeding, no compensation has been paid. But the petitioner made representation, my lord, before the authority.
Yes.
Page 21, my lord.
Yes. Page 21.
Yes, my lord.
Yes.
Which is pending, my lord.
Yes.
My lord, kindly see page 21, my lord.
21, yes.
My lord, may I read, my lord? This is for your favor of kind information that as per joint inquiry dated 29th of December 2017, to find out the utilization pattern of plots stated above, 2.98 acres in under possession of Tista Barrage, and the rest 3.76 acres is under possession of different riots. But we handed over 2.76 acres only, within bracket 0.72 acres acquired in LA case number 5 of 7980. Plus 2.04 acres vested land in LA case number 101 of 7778 to Tista Barrage. Therefore, it is an acquisition of 7879 and 7778. And if the land is utilized at that point of time, they have approached first time in the 2026. That is the representative. Prior to that, they have not communicated any.
Yes,
no
page 19, my lord, 2023, my lord, their internal, my lord, the communication, my lord. Page 20 is the 2019 communication, my lord. My lord, admittedly, they are using, my lord. No third party right has been created, my lord. My lord, my right to property has been infringed, my lord.
Page 20 is the report of the special land acquisition officer, but the land has been utilized by page 20 is the report of the special land acquisition officer, the land acquisition department. And
The picture will be cleared from page 19 also, my lord. The report of the BLR to the DM.
That is also of 2013.
2013, my lord.
No, but 2019,
yes, ma'am.
A joint inspection was held.
Yes, ma'am.
Then it was found 2.98 acres was in the possession of Tista Barrage.
Out of
acquisition was only with regard to 2.76.
0.72 excess.
Yes, 2.72, 2.04 and 0.72.
Yes.
That's 2.76. But they are in possession of 2.98. So admittedly,
Excess
22 acres is in excess possession.
Yes, that is my
So you have to compensate for that.
But prior to that has been utilized by the irrigation department.
Tista Barrage
Barrage,
Yes,
department.
irrigation department do not fall within your state.
No, then we need some instruction from this department, whether they have initiated any proceedings or not, in steps have been taken or not.
Already you communicate your decision. They have given a
Yes.
representation.
Great.
You communicate your decision with regard to that. The petitioner
I'm for the petitioner. Lordship, petitioner want to not press this application, Your Lordship, because petitioner made a representation to the National Highway Division 7, Your Lordship, but at the time of inquiry, this is come to know that this is comes under Malda Division, Malda Highways Division, Your Lordship. For that
Learned
reason,
advocate appealing for the petitioner.
For the petition in this.
Item number 14, Mr. Sanjay Shah is appearing, my lord. He is out of station. Kindly make
Out of station.
not this week, my lord.
What is this matter?
This is the affidavit of service. This is for
This is for the
the
mineral development.
land quarry part. But I applied for
Adequate compensation.
yes, madam. But a permit was given me 9 acres 17 decibel. Out of 9 acres 17 decibel.
You are challenging an order of the appellate authority.
Yes, madam. Yes, madam. My point has already been decided earlier. Coordinate price. I have another two matter.
Point decided. What point decided?
That I am entitled to compensation. Not extension. Extension will be made, will not be made as Convention Rule 16. But as I am not lifting the sand of this area, I get the compensation.
No, I could not follow. What is your case?
But I got lease for 9 acres 17
Give me a minute. Give me a minute.
Report file করতে হবে না। Report file করতে হবে।
No, you paid for extension of the period of lease.
No, both true. Either compensation or extension.
Compensation for what?
Not lease was granted me on 9 acres 17 decibel of land.
Compensation on what ground?
But
Under
I
what
could
provision?
not operate 6 acres 17 decibel because of that. That area is within the 200 meter of embankment. Now this is the prohibited area. But in spite of that, they have given lease of that. But the local area could not operate that 1.5 year. After 1.5 year, I only operate 3 acre of land. So I have prayed for that. I could not get the operation of 6 acre 17 decibel of land. Therefore, give me an extension or give compensation for
That
that.
is your representation.
Representation is page well, first P1, page 19.
Page 19.
Yes. That was decided by the DLRO, and I prefer an appeal against that order. That appellate order, I am come before your lordship. I have paid the royalty entire 9 acres.
You have not paid for compensation. Show me where have you paid for compensation. Show me in the representation you have not paid for compensation.
Not
You have only paid for extension for a further period of 24
extension
months.
and or compensation.
Where?
State.
You did not pay for compensation, Mr. Arifin. You
What
only
a-
paid for extension.
Extension and compensation. I prefer the appeal before the DLRO. That was
You have not paid for compensation. You have only paid for extension.
when the court has when it was not considered. I came before this court.
But this
Court
is,
has
there is no
directed.
paid for compensation. You have also before the appellate authority. You have not raised any prayer for compensation.
No.
Show me you have raised the prayer for compensation.
No, that appeal I have to give it.
Appeal you cannot expand the scope.
Well, in
But you
appeal,
have also not raised that point. Appellate authority, the prayer for compensation you did not raise. Only you paid for extension.
well, in appeal court, when the court has directed to file an application there
Where?
under section 51 before the appeal authority. Well, this is the second time I have come.
Show me in the appeal you have paid for that compensation.
Appeal to তোমার কাছে নেই। The order is page 32, appellate authority.
Because when you approached before the coordinate bench, you also said that I applied for extension which was not considered. That was the only relief which you claimed.
But I produced before the copy of the writ petition that. Copy of writ petition of this.
Nothing, it does not appear.
Your Lordship, kindly see that. Tomorrow, kindly see that.
But, it does not say that. Please see, because only your submission before the coordinate bench was also that extension. And where is the provision for giving you compensation under the statute? Please show me.
The statute,
Then
your Lordship, kindly see.
Then you
A statute regarding
you
compensation.
lies before the civil court.
Your Lordship, tomorrow can take it tomorrow.
Even if I accept that you have made a compensation, prayer for compensation,
Yes.
there is no statute does not say for payment of compensation.
No, regarding that matter, your Lordship, kindly see this order. This order, in that matter, that lease was stopped after 1.5 years for another purpose. Therefore, court has directed to pay compensation. As I am, it is no fault of me.
Division bench judgment is otherwise, Mr. Arifin.
But that I do not know whether this is my order. It was heard.
Bench judgment is otherwise. Dilip Mondol's case.
It was heard by this
Remedy,
court.
if any, lies in a claim for damages before the civil court. I am bound by the
Taken up
division.
tomorrow, my lord. Can you
I am
take it up?
bound by the division bench
No,
judgment.
can you take it up
Also, you
tomorrow?
have not raised any
Well, give me
prayer
the
before the appellate
well,
authority.
give me the number, my lord. I shall see that to it, and tomorrow it will be taken up. That division bench judgment.
Division bench judgment is
MAT 1309
of 2025.
নামটা কি আছে?
You are regularly doing this type of matters, Mr. Arifin.
But I shall
MHT 1309 of
Decision is only, so even if you say that you have suffered some damages,
1309 of
civil court, go there, you will be getting your remedy.
But tomorrow your lordship
So
can.
that can be quantified by the authorities. There is no procedure laid down under the statute.
But in this matter, my lord, court had directed me to how much compensation you have to
Cannot
pay.
be
I have that.
directed. Cannot be directed. Statute does not say.
But that was heard by the DLRO.
The authorities cannot travel beyond the statute. If the statute does not vest them power to decide that, they cannot compute. What will be the basis of their computation?
But I shall produce also an agreement which between the government and my client. There is a clause. They will give compensation.
In the lease deed,
In the lease deed.
where is the lease deed?
But I shall bring tomorrow. Tomorrow I shall bring them.
Yes, when
In
will
the
the
lease
copy
deed.
will be available?
Next week.
If it
Next week.
Next week.
It was
agreement. Only assistant engineer. PWD.
My lord, I'm being
What did you do? The issue is made an application, the prime minister made an economic
private
room. And on the PWD road.
My
They
lord,
made a
For his livelihood, Mr. Bhattacharya.
my lord, I'm
On his livelihood, why are you preventing, why are you disturbing him?
PWD road. They're disturbing
For
road.
his livelihood, Mr. Bhattacharya.
Lively, but I am facing problem. I'm not being able to enter into my house also, in front of the house of the petitioner. They made an application before the exchange in a PWD. They made an inquiry. On 25th, on receipt of the petition, 25th February, paragraph 18, 2026. Then,
my lord, I'm being
Well,
led by Mr.
yesterday,
Surya
my
Prasad
client-
Chattopadhyay. Yeah, only today only we have received the brief, and today only the Vakalatnama is being filed. So, my lord,
Problem. Yes.
they're on
My lord,
25th,
oh, kindly grant a short pass.
paragraph 18. That is the paragraph 18.
Paragraph?
18.
Yes, yes.
That the petitioner that said representation, we made a representation. And by the concerned department as it appeared from the postal tax report on receipt of the same. PWD had made a visit on 25th February 2026. The subject line was illegal construction made. That the respondent PWD asked the petitioner to be present at the spot and have conducted inquiry. The spot on 20 February. After completion inquiry, the concerned
official had left the place. There that they did nothing. Now, my lord, my client has received a notice from the assistant engineer. He addressed to the BLO concerned. He said,
Demarcation. For demarcation.
Demarcation. The on receipt of writ petition. A writ petition received from the by this office such and such. In this contest, a joint demarcation program is highly needed for further course of action. So you are requested to fix up the date. That letter has been written to by the assistant on BLO concern on 25th March. That copy has given to my client, my lord. Now, it is.
Now your grievance stands.
But there is section. But
grievance stands redressed now.
But your lordship knows the section 10 was Highest Act. You will initiate a proceeding.
What does it say? Section 10 of
Yes,
the Highest Act.
your lordship knows everything, my lord. Every day that you are not doing that matter. The assistant engineer PWD initiate a proceeding under section 10, and you decide the matter. That is my submission.
You will not allow the private respondent to earn their life.
But is it
why?
And not only that, Mother kindly see, yes, that after making inquiry, the paragraph 21, after causing inquiry, the pilots have threatened my client also. Yes, that is the apartment.
Go before police in action, bank.
Police station.
Lord, that notice is not annexed, my lord.
Yes, Mr. Bhattaji.
But
Go
on
before the police in
25th.
action, bank.
On 25th March, how can I? On this is the petition.
Before the police in action, bank.
Oh, that is not. I'm not saying that. I made an apartment. But kindly direct the PWD of the initiate proceeding under section 10.
Lord, that notice is not annexed, my lord, also.
Yes, after
In
filing
this
the
writ
writ
petition.
petition.
My lord, consider the representation, my lord, at page 29.
Give that. Yes, what is your instruction?
My lord, only today we have received the brief. We have not ready with the matter. Only a short passover I am humbly praying for.
ওখানে যা আছে consider হবে.
My lord, let my learned senior give the lawful points and arguments for the same.
Only consideration, only consider.
Yes, what they will give?
For law points, any
law points. Yes, Mr. Bhattaji, you have not included the law points in the petition.
Section 10, I have already in the
Where is the law point?
Yes, law.
Yes, page 19 law points are there.
Yes.
19. That will have to be rejected, Mr. Bhattaji.
What?
Page 19. Can it be page 19? See your point of law. Point of law, page 19. Prior to the cost title, 19 pages.
Oh, that should not be.
Has to be rejected, Mr.
Right.
Not in form.
That should not be. That's I have not seen the matter. That is not
rejected.
the number
That's a ABC. That's
presentation
the mistake.
Not in form. Who made this mistake? He made this mistake.
Well, I did not say, yeah, hand over the bridge. The matter is appearing. It will appear tomorrow. But
take care of him outside the court. Take care of him outside the court.
Yes.
The petitioner claims to be
I'm for the petitioner.
Yes.
The private respondent has enclosed the PWD land and my ingress egress is
Land or the road?
the road, PWD road.
Yes. What they are doing?
Unauthorized construction.
Why you want to remove all unauthorized construction, Mr. Mishra?
For my existence. For my existence.
How long it has been? This construction was made when?
Recently. I cannot enter into my the land.
Yes.
Even I cannot enter. The entire land was the.
How could he come to affirm then if he cannot enter?
It's a land. It's a land. I cannot enter into the
Yes,
land.
what is the
Purely private dispute.
private respondent served?
Yes.
Received. When they received?
26, if I'm not wrong. 26.
Yes. Why private dispute?
Purely private dispute.
Why? You are for the private respondent?
No, I am for the state.
Yes. Why private dispute? No encroachment upon the PWD road?
Nothing.
I'll be out of court, my lord.
Nothing.
I'll be out of court, my lord.
It is better if my learned friend go to the civil court. It will be better for him.
Why? Private dispute between whom?
Between the petitioner and the respondents.
Why it is a private dispute?
That is he to answer.
I will, my lord. He is submitting. I will answer, my lord. I'll substantiate his, my lord, submission.
Why you have not filed a representation before the concerned authority?
Who said?
Yes,
kindly
yes,
see my page
representation has been
34.
submitted, page 34.
34. Dada, তুমি একটু বিশ্রাম নাও।
Yes, my lord.
দৌড়াতে এসছো।
What steps have you taken?
Instruction has not yet been.
Then you are submitting private respondent, private dispute.
Then my lord kindly give another date. I shall try
Let
to
it be disposed of, my lord. My lord.
Purely private dispute. It is the duty of the concerned authority to go to
How can my landlord
enlighten the matter
it's a private dispute? I really fail to understand.
against the unauthorized construction. It is purely private dispute.
The petitioner claims to be the আচ্ছা একদম উপরে লিখে দেবেন in spite of
Here, my lord, though the land has been acquired,
yes,
compensation has not been made.
who is for the state? Who is for the state?
Yeah, Eastern Coalfield is the
Eastern
Coalfield.
Have you served? Where is
Yes,
the evidence service? Received?
Yes, yes.
Government Pleader's Office you have served? Then learned advocate appearing for $18.
My lord, this matter, Mohim Shashmol on behalf of the petitioner, due to his illness, not come to court. My lord. Only prayer, not today.
yes, service.
I do not know, my lord. Just over telephone, inform me, my lord. Therefore, not today.
And for the petitioner, my lord.
Yes.
The land of the petitioner acquired by the Eastern Railway Authority, my lord. But the compensation not made, my lord.
Yes, let me see what. Yes.
The land of the petitioner acquired by the Eastern Railway Authority, my lord.
Yes.
But the compensation has not been made till now. My lord, my representation is page number 64.
64.
It's 64.
Yes, Mr. Dey. This is
Lord,
any
in this-
instructions.
My lord, instruction is a railway is the railway কে পার্টি করেছো ও তুমি কোথায় দিবলকে my lord though this is a OC's report my lord but there is indication my lord your lordship will see this that only there is some materials only for that reason my lord I am giving you
yes
if your lordship will see this that is the land was taken by the railway পম্পা কোথায় মামলা করছেন railway manager is my lord
yes
implemented divisional railway manager my lord south another land acquisition officer were
yes have you served the railways have been made a party
yes my lord that is indication that is the respondent number that is 78 my lord if your lordship will see 78
yes
7
to serve the railways
I serve in GP office, my lord, not the railways, my lord.
Railways you have not served.
Sir, sir.
Malat, I served all. Malat, every service not affirmed.
Railways you have served.
Railway served.
Railway
served.
So I'm directing the railways to consider this.
Yes, my lord. Consider the application.
Petitioner, please file the
within a certain time.
I've said কত? 8 weeks.
Grateful.
Yes, next.
Lordship,
Yes.
we are praying for the petitioner. The petitioner praying for compensation, damage and interest with solicium as per the provision of Act 2030. The fact is this, the
Property acquired when?
acquired in the year 1988. The fact is this, the erosion affected pupil of Bhagirathi, Bhagirathi Nodi, some pupil forcibly possessed the land, and ultimately it was the land was acquired, and acquisition process has been started, but no payment has yet been made. Thereafter, in the year 2001, a writ petition is filed. Kindly see the order. Kindly see the order. Page 52. Page 52. Page 52 of the writ.
For the state. Have you served the office of the government?
All the respondents, Lord, all the respondents. This is the affidavit of service.
Yes, page 53.
Page 52, the order was passed by this honorable court, whereby the honorable court direct the writ petition, what I am reading, the petitioner has claimed compensation for land acquired. It is alleged that the compensation has not yet been paid to the petitioner. In the circumstances, this petition is disposed of by directing the concerned respondent to process and calculate the compensation and declare the award within a period of 6 months from the date of communication of this order. If that already process concluded and declared as the case may be, if the decision of the or the award, if not already been made, the payment should be made within 2 months. 2 months. In the circumstances, award is hereby passed, and the payment has not yet been made. In that case, in that event, such payment may be made within the same period. Let it be noted that I have not entered into the merit of the case. The respondents shall be free to decide the question of according to their own wisdom and discretion in accordance with law. But nothing has been made. The communication is made. Thereafter, this is the petitioner is the Shebait, and his predecessor is Shebait of Sri Raghunath Dev Thakur, and the property is of Devottar property. Similarly, there is a system who is the Shebait will be engaged one after another. This petition is filed. His predecessor, predecessor of his present petition, Guru Pita, Purushottam Das Achari. Not in the year 2009, I annexed the death certificate. He expired. All the documents lying with his, and nothing has. He was the administrative head. That is the process of the.
When did he pass away?
It was 2009. 2009, but all the relevant documents are nothing. He was the administrative head. It is the process and procedure of the Devottar estate.
Then you came to know when?
We do not. The petitioner could not trace out the relevant documents, and ultimately trace out the lawyer and obtain the document, and immediate thereafter come to me, and thereafter file a representation addressing to the respondent number 2, the collector, district magistrate, the last respondent.
What is take instructions?
If they file the report in the form of affidavit, let them file the report in the form of.
Let him take instructions. Report will come thereafter. Where have you stated that no compensation has been paid?
Not prayer A, kindly see.
No, not prayer A, in the body of.
Yes, body also I have stated. I have kindly see the. Representation, I have made a representation.
The representation in the body of the
body, collectively. That the heritage buildings, Lord.
Para 13.
Para 13.
Petitioner alleges
the land in question, the 26.44 acre land, is the only source of income of the Devottar estate. So that income was stopped.
I am asking you, you have said that it was not paid. What is the source of your knowledge? Because in 2001, you were not in the helm of the affair.
But it is the
alleges that Please give him a copy.
আচ্ছা দিয়ে দিচ্ছি
Yes.
দিচ্ছি আমি বাইরে গিয়ে দিচ্ছি হ্যাঁ?
21, yes. Private respondent,
No, only the state, my lord. I am praying for, my lord.
private respondent.
I am praying for, my lord, the disburse of my compensation amount as per the order passed by the, my lord, the
No
special land
dispute between the interstate owners with regard to apportionment. No.
of set all matters, my lord, settled.
All settled. Then
But
why
the
have to approach the court?
The amount not been yet been disbursed by the, my lord, the authority.
Acquired under what proceeding?
1894 Act.
1894 Act.
Thereafter, my lord, the challenge the compensation amount 18 paper, section 18 reference paper, order passed. My lord, thereafter, my lord, the matter, all matters, my lord, sent to the local adalat. Local adalat matter settled, and my lord, the concerned court, my lord, passed and degree, and my lord, the give the details, my lord, for give direction for the special land acquisition character to disburse that amount. Like in similar circumstances, my lord, the sum of the persons, my lord, approach before this honorable court in earlier occasion also, and honorable my lord, coordinate bench, my lord, the past similar types of order, my lord, I have annexed page 45.
That is in 2012.
Yes, my lord, I am relying that.
Yes, since they are paid for payment of compensation as per the judgment passed in reference case, let me take instruction.
Please take instructions.
Yes,
How soon can you
yes,
pay this?
Yes.
Because in the Lok Adalat, state also appeared before the Lok Adalat. That compliance of the order of the Lok Adalat.
Yes.
Yes, my lord, learned government pleader is present.
Where?
Page 15.
15.
15. My third line. Learned about the claimant representative land acquisition department are present. Learned government representative is present.
Yes, Lok Adalat's award. Why are you not implementing?
That is I am saying, my lord. Let me take it, sir.
The petitioner alleges
Private response, but my lord, it is showing item dispatched. I have sent my lord,
service is not complete.
Service is not complete, my lord. It's showing item dispatched.
22 though. This is 22.
Bharati Ghosh. Bharati Ghosh.
22.
Yes.
Yes, Mr. Mahato, what is the
My lord, this is the purely civil dispute between the border felling of trees.
felling of trees?
Yes.
But I have made a representation
Undivided
before
property.
the divisional forest officer. my
Now
lord.
forest of he had made
Felling of trees. So
Fel-
there is a property is a co-sharer property.
co-sharer property.
What is the dispute?
Dispute, my lord. I am the one of the co-sharer of the property. My lord, thereafter, my lord, since my lord, the other co-sharers were felling down, my lord, valuable trees from the property, my lord, I made a representation.
Where is that?
Page 24, my lord. Page 24 is my representation.
Yes.
Milord, at page 26, Milord, para 8, Milord, I have categorically stated, Milord, what are the trees that has been felled.
Paragraph 8.
Paragraph 8, Milord. In spite of the effort, Milord, previously, Milord, I filed an application under 163(2) BNS.
So then proceed there.
No, Milord. Milord, thereafter, Milord, para 8, Milord, I have stated, Milord, that in spite of
Proceed
that.
in BNS.
So, Milord, after 60 days, Milord, nothing remains in there.
Yes.
At para 8, Milord, I have made a specific allegation, Milord, that in spite of the aforesaid order, again on 20th February 2026, the aforesaid persons along with their main agents and associates went to the scheduled property and started felling.
So you lodged a complaint with the division forest officer?
Yes, Milord.
Now, any steps taken by?
Milord, till today, no communication has been made to.
Who is representing the division forest officer, Mr. Mahato? You are representing?
No, not government official, my lord, I must explain.
Yes. So what is your instruction? If the one thing is with regard to the private dispute, but felling of trees, no one can fell trees without your permission.
Felling of trees, my lord, permission is required, but he is coming in the land jurisdiction. He is coming under the land jurisdiction.
But it should be going under which jurisdiction?
And residuary.
Under land, there is also miscellaneous.
Land is on land. School building is on land.
Milord,
So
with,
dispute.
Milord, with regard to Milord, the non.
My lord, let the division officer consider his representation and take steps.
But a private respondent has not.
Private respondent.
Their presence.
Milord, there be an order, Milord, I shall serve with the private respondent again, Milord. It's showing item dispatch, Milord, I shall serve.
When have you sent?
Milord, I have sent it on.
Which place?
Bakrahat, Milord. I have sent it on 25th of March.
5th of March.
Yes. It is not complete, Milord. Kindly, Milord, grants a week's time, Milord, I shall, Milord.
What is the location of those registered envelopes as per the track report?
Shialda.
From where have you posted?
Bodo Bajar. Bodo Bajar.
Mr. Mondol, honored advocate. Yes.
I am the petitioner, Your Lordship. This is a every service. There is no private respondent, Your Lordship. Lordship, in front of my land, there are CPWD roads, Your Lordship, but till the
in front of your land, there is a
CPWD road, Your Lordship. But
Yes.
LR Mozambique, this is not mentioned, Your Lordship. For that, I made a representation to demarcate their land, Your Lordship.
CPWD. What is your allegation? What do you want?
I want to demarcate their CPWD roads, lands, Your Lordship, and that helps to me to make a construction in my land, Your Lordship.
Page 12, their representation, my lord. That is on 16th March 2026.
You are the recorded owner of which plot?
Plot number 3920 and 4268. I mentioned it under Dokkin Mazadar Moja.
3920 and
4268.
4268.
Lordship. I annexed the record of right, your lord.
How have you become the owner? You have a purchaser. Where is your deed?
But I am not a purchaser. I am the from my father's land.
Your father purchased?
Lordship.
When?
I didn't know, your lordship, but ancestor property, your lordship.
Where is the difficulty? You measure your land, you demarcate your property. Who is stopping you?
Lordship, in Moja map, the roads was not mentioned, your lordship. Though, although they acquired, your lordship.
You have your property. You know the extent of your property. You demarcate your property. You as a boundary wall. Where is the difficulty? The respondent authorities are not creating any disturbances. You have not made any allegation against the respondent authorities.
Lordship,
Who is really disturbing you in demarcation? Who is disturbing you in demarcation?
Actually, your lordship, until
If you face any difficulty in demarcation, which authority you have to specify? Otherwise,
Lordship,
a blanket order of
I engage.
demarcating your property.
Lordship,
Nothing stops you from demarcating your property.
Lordship, I take appoint a local army, your lordship, but
Do that. Nobody is stopping you.
until unless there is a Moja map, your lordship, and there is not mentioning in the road.
Know the exact location of your property. That's your problem. That's your problem.
No map, but your lordship. Lordship, unless they measure their land, how I?
Not necessary. You know your land. Just demarcate your land. According to you, Moja map does not show road. You know your land. You know the position. Demarcate your land.
আমার জায়গার উপর দিয়ে রাস্তা সেটা তুমি জানছো না রাস্তা তো আছে এক্সিস্টিং রাস্তা সেটা যে তোমাকে
Who is stopping you from demarcation?
Lordship,
you demarcate your own property. No difficulty on that.
Lordship, I start my construction, your lordship. At that time, the police officer state me that first demarcate, then start my construction.
Have you stated that? Which paragraph?
I think I not. Point number 6, your lordship.
No. You have not made any allegation against the police.
No.
Then
I start my construction.
There was a problem arose when the petitioner started construction. Who created this problem? And there are several co-sharers of these plots.
Lordship.
Then you have not implemented them as parties.
If lordship,
I do not know which portion is your property. Its only shares have been indicated here. If there is a dispute, sir, if there is a dispute with regard to the demarcation intercept between the co-sharers, your remedy lies elsewhere. Or if you know your property, you demarcate, you proceed. Writ court cannot help you.
lordship, until unless they
who is creating these disturbances? Who is raising a dispute?
If local surveyor made a demarcation to my property, I made a construction. If after that, in any person made a complaint, and
so there is a dispute between the rats intersect.
Until unless the government demarcate their land, how I demarcate your lot? My plot is
include all the co-sharers. Let them come. It appears that there is a private dispute. It's a private dispute, or you can do, you can proceed according. So the two options open. On this vague allegation, I will not direct demarcation by the authority.
My plot is adjacent to the road, your lordship. My plot is adjacent to the road, your lordship. In my plot, they acquired
What is
some.
your name?
Sahadev Mondal, Milan Mondal, Kritish Mondal, your lordship. Sahadev Mondal, Milan Mondal, Kritish Mondal, your lordship.
Milan Mondal,
Sahadev Mondal, Kritish
Sahadev Mondal, and
Kritish Mondal.
Kritish Mondal.
Three brother, your lordship.
The petitioner has.
I am for the petitioner, my lord. Yes, my lord. In this case, I have served my copy to all the state respondents. There is no private respondent, my lord, but few service is not confirmed yet, my lord. The fact is, my lord, this is the scheduled land is desert land under Jilla Parishad, and more than 50 years we are doing our business, making hut in this area, and suddenly Jilla Parishad has issued notice for offering the lease agreement. All the petitioner have submitted their prayer before the authority concerned, page number 48, my lord, annexure P5, submitted on 31st December 2025, showing their interest, page number 48.
48, yes.
Showing their interest to take the lease, and they have only prayed to define the terms, condition, and the rate of the lease agreement, lease of this premises, in accordance with the other lease agreement has been made in the beside the plot. During pendency of this prayer of the petitioners, respondent authority has started proceeding under Eviction Act, my lord, page number P6, page number 49, my lord.
Yes.
And in accordance with the impugned report submitted by the additional executive officer, which is not correct about the petitioner's intention, subdivisional magistrate has started proceeding as per page number 50, my lord. So petitioners are praying to consider their prayer, which is pending before the authority, and stay order is praying before this honorable court for this purpose, my lord.
hearing differ হয়ে যাচ্ছে খালি, and hearing was earlier scheduled, they only differing the dates.
Yes, what is your instruction?
Getting any instruction as yet, madam.
No instruction.
My lord,
If the proceeding is pending, approach that authority.
my lord, authority is not considering this
What
prayer, my
happened
lord.
on 24th of March 2026? The hearing was fixed on 24th of March.
Yes, my lord, we attend this hearing, but there is
I'm
no,
directing them to communicate the order. Thereafter, you can challenge that.
but they are not considering my prayer until and unless they are
Might
considering my
consider,
prayer.
now the order has not yet been communicated. If they pass an order, then you will be at liberty to challenge that.
My lord, they are proceeding under Eviction Act. So any day we shall be evicted from the scheduled property. We are depending on the bread and butter.
That you have paid rent.
My lord, we have not paid any rent, my lord. Only they have offered for lease agreement. We have applied accordingly.
Finding, whereas it appears that you have applied for the short-term lease, but out of 16 persons, out of 28, 16 has neither paid the prescribed short-term rent nor have obtained any valid permission. That is why you are in occupation without any short payment of rent.
Yes, my lord, my application is 31st December. And this reply is
31st of
coming.
December.
Yes,
And
my lord.
since when you are in possession? Since
More
when
than
you are-
more than 50 years, my lord.
More than 50 years.
Yes.
Have you paid rent for these 50 years?
Government is asking rent very recently, so we are ready to pay. We are binding by all the terms condition. Only the dispute is
Make that prayer before the. Have you made that prayer before the authorities?
Yes, my lord.
That,
Yes, my lord. We have.
that will be considered. I am directing them to pass the order.
Yes, my lord.
The petitioner alleges that the respondent authorities have not considered their prayer for grant of short-term lease. Stop. A record reveals that a proceeding has been initiated by the subdivisional magistrate under the provisions of the public land, West Bengal Public Land within bracket eviction of unauthorized occupants bracket closed Act 1962. First up, from the materials disclosed in the writ petition, it appears that hearing date was fixed on 24th of March 2026. First up paragraph, the learned advocate appearing for the petitioner submits that the petitioner duly attended the hearing fixed on 24th of March 2026 and made submissions with regard to grant of short-term lease before such authority in course of hearing before such authority. First up paragraph. Since the proceeding has been initiated and it is the case of the petitioner that the petitioner has prayed for grant of short-term lease before such authorities, this court is of the considered view that the interest of justice would be subserved if the authority is directed to communicate its decision of the hearing that took place on 24th of March 2026. First up, the subdivisional magistrate, Tomluk, Purva Medinipur being the third respondent, is directed to communicate the decision of the hearing that took place on that was conducted on 24th of March 2026 to the petitioner as expeditiously as possible.
Considering my prayer, my lord.
Said that they might consider as expeditiously as possible. I'm not fixing any time limit because that might go against you as expeditiously as possible. First up, in case The said respondent authority is of the view that further hearing is necessary. It will be open to such authority to communicate the next date of hearing to the petitioner and to pass orders thereafter in accordance with law, and to pass reasoned orders thereafter in accordance with law as expeditiously as possible.
My lord, my prayer has been considered. My prayer that is pending before the authority.
So I have said that you have made submissions with regard to grant. I have recorded that.
My lord.
Yes. Who is for the port trust? You are for the port trust.
Yes, Your Lordship. We have been instructed to appear, but my lord, we have not yet received a copy of the writ petition.
No, yes, but only one thing you are aware of the other matter which the port trust has filed against the state.
My lord, that is pertaining to the Estates land, Your Lordship. It is under the Estates Act, my lord, where certain portion of land belonging to the port trust was sought to be vested by the state. Now,
But the subject matter of dispute in this writ petition also falls within a portion of that land.
my lord,
That's Mr. Majumdar's submission.
my lord, the difficulty is what I could gather from the port trust officials is that probably there is a notice of eviction.
Yes.
There is a notice to quit that has been issued. No steps have been taken for eviction as yet. My lord, there is a date fixed for handing over of vacant possession of the land in question.
This will entail in a proceeding under the 1971 Act to
Yes,
the
Your
estate
Lordship.
officer.
So only one thing, the
Yes.
limited prayer of Mr. Majumdar is that this should be released to be heard along.
No, I don't say it should be released. No, I say to avoid a contradiction.
No, Your Lordship, there that Estates, the
Say
ma-
that these two writ petitions are to be heard together so as
My
to
lord,
avoid any conflict of judicial
that particular writ petition,
it in a better way.
that particular writ petition, yes, that particular writ petition has nothing to do with this, my lord. There is a severance of tenant-landlord relationship in this case.
No, please come to page 43. That's the order under challenge in that other writ petition.
My lord, that is the
I
order
just
of
take
vesting.
the operative portion of that impugned order in the other writ petition. A fresh notification of vesting under the West Bengal Estates and Forfeitures Act in respect of the area of land.
Mr. Majumdar, only one thing. Here, according to you, there is a lesser lessee relationship. Can you challenge the title of the
No, I
lesser?
am not challenging.
That is exactly
Today,
what you
today the question,
that is exactly you are trying to do.
No. I said
only a severance of the.
I said, whom should I pay the rent to? I wrote to the port trust authorities. In view of this development, do you undertake that if
you
I
have
pay?
accepted, you have paid rent to this authority.
At one point of time, there was a.
Now you cannot challenge that. 116 is a bar.
Yes.
There was a.
116 is a bar, Mr. Majumdar.
Section
Perhaps
122 new
this
section.
might not be
Yes.
related to that.
There was a time. There was a time period during which they were divested of the property insofar as the title is concerned, not physical possession. The matter went up to the Supreme Court. The Supreme Court had remanded it. Now the fresh cause of action has arisen.
Only a dispute with regard to the landlord tenant or the lesser lessee
Yes,
relationship
absolutely.
will be considered. Nothing, the title of the lesser will not
Absolutely, Your
be
Lordship.
in issue here.
No, please come to page 43 once.
Subject to correction, Mr. Majumdar, you cannot challenge their title now.
I am not challenging a title. Please come to a fresh notification of vesting in respect of the area of land mentioned in the schedule of the show cause
That
notice.
might be vested. Mr. Majumdar,
That's right.
there are, even if a property is constructed by a person on a vested property, let us take at that. And that person inducts you as a tenant. Now there is a dispute that lesser, he wants to evict you. He gives a notice of eviction and you accept. He inducted you, you are all along paying rent, to them. Thereafter, certain dispute arose. He want to evict you. You cannot take the plea that the landlord do not have any title.
I am not saying of a title. No, this is please come to.
Vesting, that shows that the port trust do not have any title. That perhaps you cannot take.
I am not challenging the title. But I say that to whom should I pay the rent to? I have written because
To whom is the port trust? Because you cannot recognize any other third party except the port
but
trust.
for a time period, when I say that if I pay this rent to you, will you be
IFSC view, those two issues are different.
will you be refunding this amount to us? I have written these letters to us in the event of the proceeding going against you.
That's a dispute with regard
That's
to
right.
the matter. So that vesting issue cannot be the.
No, I leave it. I am ready and agreeable to proceed this matter before your lordship also. That's what I am submitting. I have not said for release of the matter. I was only.
I'm not saying release. No, because your prayer was that the two matters are interconnected.
It concerns the same. Yes. Now, I'm not.
Issues are different.
As of today,
maybe the same plot. Even accepted. Plot is seven. The same. Issues are different.
As of today, there is an order. There is the learned advocate, the general who represented the state, the additional advocate general. He said that we are not executing the order, but the order does not get stayed. That was the submission made in court. That order is also there. So in that context, not the question arises, not when there is an order. But I am not challenging once again the title of Kolkata Port Trust. I can't. But I have not challenged this also.
Yes. So if you cannot do so, so that proceedings will have no relevance.
No, Lordship, no, take it up. Lordship may take it up.
All right. So
My lord, the only thing is that it's a notice to quit that is being challenged probably in this writ
sir,
petition.
only I have kept it under to be mentioned because it
Only
was
for
mentioned
this.
when only for not release. Mr.
No, no.
Majumdar has said it in a better term. So two matters are to be heard analogously according to Mr. That is why I have kept it as to be mentioned.
My lord, probably
So
not,
now
my
I
lord.
am
Yes,
facing,
probably not, your lordship. My lord, probably not. It does not concern with the estates
Okay,
matter.
so,
that is being-
you can make your submissions. I direct him to serve a copy.
It's served.
For that,
Yes,
I have
let-
only given this, posted this under the
Copy.
heading to be mentioned.
Yes.
So serve him a copy. So
Yeah, it's a service has been effected already.
My lord, I don't know, maybe with
when do you
line-
want?
my lord, whatever your lordship thinks it's
But the
fine.
day expires today. The time to hand over possession is 1st of April.
My lord, we
So
have
will not
to.
hand over possession,
Yes,
Mr.
of course, my
Majumdar.
lord,
Will
without
you
the
comply
BPI.
with that notice?
But your lordship knows the 71 Act proceedings have to go on.
So that has to start. So nothing. So when do you want?
But I leave it to that.
First of April will be a good day for you.
Any day is good day.
1st of April.
My lord, if it can be a 1 or 2 days later, my lord, I need to seek instructions. I need the documents.
Because 6th is the monthly day.
7th, Mr. Majumdar.
Yes.
I'm keeping that avenue also open because let me see it because the subject matter, Mr. Majumdar Lahan's Yes, state, you have got the copy.
Yes, I got it. In fact, another copy you have because
Another copy, why?
already
That you have to request. I cannot direct Mr. Majumdar. That you have to make a request to Mr. Majumdar. If he agrees to that, yes. Call the next matter.
No, no, it's a request to.
Yes, yes. Make a request. I don't think Mr. Majumdar will. Mr. Majumdar, please supply.
Yes, yes, no, we are supplying here and now. Item 25, I'm the petitioner. That petitioner is the recorded owner of 9 decimal of land, my lord.
Sir.
And petitioner land is situated adjacent to the
We
PWD land,
mean
my lord.
that
And now, my lord, the concerned authority making a hydrant, my lord, without acquisition, my lord. Petitioner
Yes.
made a
Yes, my lord.
representation before the concerned authority.
My lord, today, my lord, I have received the report from the my lord, police authority.
Yes.
My lord, his particularly, my lord, this petition actually, my lord, is not maintainable because his particularly, my lord, allegation is against my lord, one Bidesh Ghosh, the contractor, and alleging the allegation against the said my lord Bidesh Ghosh, he filed one miscase in the lower court below, and in the said miscase, my lord, the landed court below directed
That
the police
agency
authority.
must have been engaged by the authority.
Yeah, by the authority, and BLRO made an inquiry. The inquiry report was submitted. After inquiry perusal of the said inquiry report, it has been found, my lord, the land is not belong to him. There is no question of encroachment, and this is non-suited land. And thereafter, my lord, the proceeding was started, and BLRO, my lord, said after one perusal of the said proceeding, said report, my lord, the construction was again started. My lord, during starting of the said construction, this petitioner, along with other henchmen, they created so many nuisance, and also, my lord, they prohibit, my lord, obstructed so, my lord, rudely against the, my lord, main of the PWD authority, and also the against the main of the, my lord, the said, my lord, contractor. That thereafter, my lord, after perusing the report, the, my lord,
In which
kindly
plot
come-
of construction is being made?
Kindly come page number 19, my
No, what is the plot of land?
Dag number 527 1345. This is the petitioner's dag number, my lord.
527. Where have you stated? Which paragraph?
My lord. My lord, kindly come, my lord, page number 4, paragraph number 4, my lord.
527 by 1354.
1354.
Show me your.
My lord, your lordship.
Record of rights, my lord.
Yes.
My lord, in front of this petitioner's land, my lord.
Page.
My lord, page number 4, my lord.
No. Show me the record of rights. Which page?
Page 19, my lord. I have annexed the record of rights, my lord. And record of rights, my lord, in the name of Noyantara Dotto. He is the petitioner of this petition, my lord. And it was 9 decimal, my lord. Petitioner's land, my lord.
Yes.
And my lord,
Yes, my
in
lord.
front, my lord, in
My
front
lord,
of
my lord, your lordship kindly come to her. Your lordship kindly come to a report, my lord.
Yes.
Page 2. On 20, my lord, second paragraph, my lord.
Yes.
On 22, 2026, BL and LRO, Satana submitted a report, Vaidich office memo number ato.
Was constructing over 529 by 557.
529 by 557. 529 by 557.
So I restrain you from using this property.
That
I
is,
record your submission, but you cannot use
my lord,
this property.
during this time, my lord, I have also contacted our, my lord, PWD authority as well as the DM. Yes, yesterday also I contacted them. They are saying that although the work has been started on some non-suited land, wherein, my lord, the petitioners has no interest at all, and also there is no question of encroachment, they will make an further inquiry, the PWD authority as well as the DM, and also submit the report. So kindly give me 1 month time, because this is during, my lord, 1 month or 15 days time during, my lord, election season. They have told me today. So kindly give me some time.
Do that,
In the meantime,
but I record your submission that is on another property. I restrain you from using
and,
the petitioner's
and also your lordship kindly come to the report, the, my lord, and also the, my lord, annexer P3. Your lordship kindly come to annexer P3.
Yes.
Annexer, my lord, P2, first annexer P2 of the AGM, executive magistrate.
Yes.
The second party, that is, my lord, the petitioner. Files put the second party here in, my lord, Swades, my lord, the Dinesh, my lord.
As per the LR map, my lord, road is wide 30 feet, my lord. 30 feet road is already been constructed, my lord. And without acquisition, my lord.
My lord,
petitioner's
my lord,
land
the
has been,
second
my
party
lord,
is Bidesh Ghosh. My lord,
Yes.
this Bidesh Ghosh is the second party where, my lord, to whom he has made the, my lord, the second party in the, my lord, complaint petition in the lower court below executive magistrate. Here Bidesh Ghosh has been major party in the writ petition.
Yes.
My lord, if Bidesh Ghosh is the second party, against whom he made a complaint. On the basis of the put up petition made by the Bidas party, Bidas Ghosh, this is the order passed by the executive magistrate. My your lordship, come to the said order. Kindly annexer 2, annexer 2. The second party files a put up petition through his engaged learned advocate, wherein he prays for drop in the instant case. Peruse and consider the put up petition allowed and to be kept with the case records. The report from BL NRO Chatna is received and kept in the case records. Peruse the inquiry report submitted by BL NRO Chatna, Bhaidi's office member number report, and it transfers. But from the said report that the second party are constructed a drain as per work order passed by the PW department over another non-suited land, that is 529 by 5.7, and nothing adverse found against the second party over the suit land. Being satisfied the report, the IC Chatna police station is directed to ensure that the first party, that is the petitioner and his money henchman, are not to create any nuisance against the second party over the non-suited land. Otherwise, the strong action may be taken against the petitioner and also directed to
Do
maintain
that.
petitioner.
If he restricts
Thereafter,
you from
they have been in,
creating land by-
they have been arrested.
Let them arrest. I'm not interfering with that. Asun. The petitioner alleges, the petitioner claims to be property junction is there. You can take your own time.
Yes.
Item number 23.
This one I am for the petition. The copy has been served. The last occasion, my lord, the state also appeared. The
Last occasion,
state appeared, my lord, on Friday.
Who is appearing for the state? Who appeared for the state?
I don't know exactly, my lord. No, my lord, but who was there? Number.
Yes, what do you want?
My lord, a proceeding has been initiated, my lord, pursuant, my lord, to an order of this honorable court, my lord, by the DLLRO, my lord. Kindly seize, my lord, first man.
DLLRO initiated proceedings for what?
For my lord, there was an allegation of encroachment on the, my lord, the government road. Therefore, my lord, the DLLRO, my lord, kindly, my lord, takes up page 42 once, my lord.
42.
My lord, this was filed, my lord, this public interest litigation was, my lord, preferred by the private respondents of the writ petition, my lord, of this instant writ petition.
Yes.
So, 26. My lord, pursuant to this, my lord, kindly, my lord, takes up, my lord, page 43.
Yes.
My lord, paragraph number 10, my lord, kindly seize. For the reason the writ petition stand disposed by giving liberty to the petitioner to submit a fresh representation to the fifth respondent, namely the district land and land reforms officer, Purva Medinipur, along with a copy of this order. If such representation is submitted, the fifth respondent shall consider the same in accordance with law after notice to all concerned and pass a reasoned order and communicate the same. My lord, pursuant to this, my lord, although, my lord, no representation was, my lord, submitted, my lord, by the private respondents, my lord, the DLLRO took up this matter. My lord, kindly, my lord, see page 45 onwards.
Yes.
Now, my lord, the difficulty is that, my lord, the fact that has been narrated by the private respondents is absolutely contrary, my lord, to the records. Kindly seize, my lord, page 46, my lord. In the writ petition, my lord, in the previous writ petition, my lord, we were not impleaded. Before, my lord, the DLLRO, my lord, we were not called for, my lord, called for the hearing. And as such, my lord, kindly seize. My lord, kindly, my lord, takes up page 31. Page 31, my lord, is the latest record of rights, my lord. Plot number 921, the total area is 23 decimals. All the riots are mentioned. Who are the petitioners? And my lord, kindly, my lord, takes up the recording of page 46.
Yes.
Page 46, my lord, the second paragraph starts with the brief fact is that 0.12 acre out of 20.23 acre of plot in question, that is CS, RS as well as LR plot number 921 of Mouja Kaulikhali, jail number 91 PS Chondipur, was acquired by LA Purva Medinipur wide LA case number such and such. Of the said plot has been recorded in favor of the PWD road in respect of LR Khotian number such and such. Rest 0.05 acre of land is recorded as Rayati Khotian. Now, my lord, kindly, my lord, takes up page 31 once.
Yes.
31, my lord, kindly sees the plot number, my lord, is 921, the same plot at the my lord, top left hand side.
Yes.
My lord, kindly sees the total area 23 decimal. And my lord, the riots mentioned in the said plot. They are, my lord, the present petitioners. My lord, our prayer is, my lord, that this application, this proceeding is to be, my lord, reheard. Since, my lord, it has been disposed of, my lord, by passing this order.
The lordship, kindly come to page 46.
So this directed to undertake a field inquiry.
Yes, my lord. What,
This
my lord, I don't know what prompted my learned friend, my lord, to whether any.
My lord, kindly says, my lord, the recording of this order. The order, my lord, starts at, my lord, recording the recording states that the brief fact is, my lord, 0.12 acre out of 0.023 acre in question is
Well, it will be a field inquiry and
Was
demarcated.
well, the proceeding has been disposed of. No, well, without giving an opportunity of hearing my lord, to my lord the riots. But our name is my lord, our names are recorded in my lord the my lord the record of rights.
My lord, I am for the private respondents.
My lord, I do not know what is the prejudice in the order. The BLRO has been directed whether there is any encroachment, and this is, my lord, in compliance with the order.
All concerned.
In compliance with the order of the, my lord, the division bench of, my lord, in the PIL matter.
এইটা পড়ো, to issuing notices to all concerned
My
parties.
lord, if your lordship kindly come, my lord, the concluding paragraphs. The BLRO Nandigram 2 is directed to conduct a field inquiry, issuing notice to all concerned parties to demarcate the actual area which has been acquired by governed, as well as identify the land of PWD along with the land being possessed by the riot. He is also instructed to rectify the records if found any discrepancy. PWD is directed to remain present during the demarcation and extend possible logistic and technical support this part. The SDO Tomlok is directed to maintain law and order. Now, how any prejudice may be caused to the petitioner in this order?
My lord, kindly considers, my lord, this aspect, my lord. My lord, rectification of record of rights has also been, my lord, directed by this order, without, my lord, giving any opportunity of hearing.
If any discrepancy, not a discrepancy.
My lord, already, my lord, there is a recording in the order, my lord, which, my lord, is contrary to, my lord, the records. And, my lord,
What?
My lord, this part, my lord, I'm, my lord, relying on, my lord, page 46, the second paragraph.
Yes.
My lord, this, my lord, and I'm showing, my lord, page 31.
If there is any wrong, that should be corrected by them with producing the records.
Yes.
Page 31, my lord, kindly sees 23 decimal.
What is your name? All of these are petitioners.
My lord, Kalipodo Bishai is, my lord, the petitioner number 1. Yes, yes, my lord. My lord, the first name kindly sees, my lord, only, my lord, I'm taking up, my lord, one instance, my lord, see the, my lord, kindly sees, my lord, the first name.
PWD road is 6 decimals.
Yes. That will be demarcated.
Yes.
Only PWD is concerned.
The division bench directed. Please kindly come to the division bench.
Yes, my lord. Page 42 starts.
Page
42, my lord.
Division bench order was that if there is any encroachment on the government property stated to have been acquired for public purpose, the authority should look into the matter. Stands disposed of with a representation to the DLR if such representatives shall consider such and such. So only there was an allegation that there was an encroachment upon the PWD road. For that purpose, the DLR has directed the Block Land and Land Reforms Officer to undertake an inquiry exercise to demarcate. So what is the difficulty?
Well, page
so you are not saying that the PWD has not acquired 6 decimals.
No, well, some of the plot with the PWD has acquired.
That has been acquired. They will demarcate, and if there is any discrepancy in that recording of the record of rights, if it is found no, not 6 decimals, 2 decimals, that recording will be only rectified.
Well, kindly consider.
That can adhere to your benefit also.
Well,
so now by this, it has been said, if there is any discrepancy, then by this correction has not been directed. Next is PWD was directed to
present.
And if there is any encroachment, proceeding is to be
initiated.
What is the difficulty?
Well, kindly, my lord, take some, page 43, paragraph number 7.
Yes.
The petitioner should admit that out of the total extent in the said plot number, 6 decimals of land is under private ownership. This is exactly what the difficulty is, my lord. Well, page 31, my lord, kindly sees 23 decimal is under private ownership. This writ application was filed under the wrong premise, my lord. That is the difficulty, my lord.
That may have
My
been,
lord,
but
let an opportunity be given to me, my lord, for
division bench did not go into that. Division bench only directed demarcation of the
Yes.
PWD.
my lord, whatever, my
No
lord,
difficulty
my lord,
of-
whatever, my lord,
difficulty at
my lord,
all.
kindly consider.
Already 30th March has been fixed for demarcation.
My lord, whatever.
Demarcation, you remain present.
Yes,
I allow
you remain
to be
present.
Yes,
present
yes,
also.
yes, yes,
Okay,
yes.
oh,
My
30.
lord, remain present and my lord, submit my objection, my lord, if there is.
Milord, for private respondent, it is my humble submission, Milord. This is the direction of the division bench, which cannot be challenged before the single bench. Milord, second point is, so it is not maintainable. It is not maintainable. My lord, second point is regarding dispute of record of rights. It should be disposed of by the honorable tribunal, not before this honorable court. My lord, my third point is, which the petitioner is afraid of, and he's suppressed the fact that the purchased land, from the purchased land, already 100 rupees 45 has been taken as a compensation in the year 1950 by the seller. So there is no question of selling of 23 decimal of land, which is suppressed by the petitioner. This is why he is afraid of by this fact.
I could not follow this.
In the year 1950,
Yes.
there was a land acquisition case number 4 by the year 1951-55.
How much portion was acquired?
12 decimal, my lord.
6 decimal.
12, my lord.
7 decimal.
My lord, this is the last paper, my lord.
My lord, kindly seize, my lord, paragraph number 3 of my writ petition.
And rupees 145 has been already taken. নিশ্চয়ই দেব।
Yes, Mr. Mahato, it says 12 decimals has been acquired.
My lord, according to the order, my lord, my lord, if it is not found.
Yes,
and
more
I
than
think
one-
that is why it has been said that if any
if any,
discrepancy-
and not only that, my lord,
Kindly, my lord, allows me to
and
retain present
and not only that, my lord, there is a forgery. There is a forgery, my lord. This is the KB book. The purchaser name is Nirmala. Yes, seller name is Nirmala. No name of such person is present by the seller family. So this is the fact of the forgery sale, and deed is completely forgery. This is why he is afraid of.
Which deed is forgery?
The deed submitted by the petitioner before this honorable court.
Which deed? Please show me.
Start said, my lord.
25 কি একটা 71
25, my lord.
Kindly go through the KB book. Nirmala has been solved. No such person is present. And after this acquisition of 12 decimal of land from 30 decimal, rest is 18. So there is no question of 23. This record is also forgery record. The deed is also forgery. So it need to be come under the truth of investigation. Nobody can suppress the fact. Public litigation was filed accordingly to reveal the truth of the fact, and that is under process. He is afraid of the submission of original deed. This is why he has come here. So it should be dismissed and with cost.
What was your allegation before the division bench? What was your allegation before the division
Before
bench?
division bench, my allegation was only based on 2 acquisition report, my lord. One acquisition was held in the year 1950, 51-52 by the LA case number 04. 12 decimal of land was acquired by that time, and that compensation was paid to the seller of this deed has been submitted by the petitioner. And second LA case was 129 in the year 1980-81. That time also compensation has been received by the petitioner. No. It should be also revealed by the state authority if they submit the entire report. That has been suppressed also. So 12 and 12, 24 decimal of land has been acquired by the state authority in the year 1951-52 and in the year 1980-81. So 24 decimal of land has been acquired from 30 decimal of land. Rest 6 decimal is rest there for private purpose, private land. So it should be revealed by this investigation. There is no illegality in the order passed by the learned DLLRO and the proceeding going on by the BLLRO. So his petition is completely illegal, vague, and there is no merit. And not only that, he has suppressed the fact by misleading the court in the page number 11, my lord. In the page number 11, I'm reading the line that has been submitted by the petitioner. They have written a baseless decision as per LA case number 04 of 1951-52, 0.6 acres of said plot has been recorded in favor of PWD. This submission is wrong. There is a end also. Page number 11, my lord.
Page number 11, yes.
The word baseless decision. First paragraph, land reforce officer.
Yes.
And
First paragraph, 5 lines from the bottom.
After baseless decision, in the recording that was the brief fact of the DLLRO, there was a word end. He has eliminated the word end, and meaning is completely different now. So his submission is completely vague. There is no merit of his submission and allegation. Only investigation is under process, and he has been made party. He is present there. He need to submit. He need to cooperate. He cannot force to stop the proceeding.
My lord, my only allegation was I was not made a party. My lord, an opportunity be given to
No,
me
that
is my only
that
allegation.
time matter was against state, because state is not revealing the fact of 24 decimal of land was acquired in two page 1950 and 1980. So my grievance of point was that time against the state. There is no question of to make party that petitioner.
Issuing notices to all concerned.
Not only in this occasion, there is so many interested party from this local area who has also shown their interest, and they are now included in this proceeding. So there is no illegality, and no, in the eye of law, no court can suppress the fact of the truth that 24 decimal of land has been acquired.
24 decimals has been acquired.
Yes, my lord, from 30 decimal of land.
My lord, may I submit now, my lord?
Initially, it was 30 decimals.
My lord, this is my latest RTI. From plot number 99 to 1, my lord, 12 decimal of land has been acquired by LA case number 1 to 9. That question has been filed by me in my RTI. Kindly, next 2 page after, my lord. My question was there. There is several disputes, my lord, and not only that, this is the map that has been acquired by the National Highway Authority in the year 1950. It is shown that more than 11.82 decimal land was acquired that time. So there is no question of rest portion 23 decimal, because before that they have purchased in the year 1978, 72. But land acquisition was done in the year 1950-51. More than 12 acre has been already acquired. This one also map is also existed National Highway. As he is afraid of revealing the truth, now he is coming and harassing us. For this harassment, he should be punished by the cost.
Yes, Mr. Mahato, how
No, my lord, according to the record of rights, kindly come page 24, it is 23 decimal.
The total measurement is 23.
My lord.
So,
Sir, 6, my lord, we are claiming PWD 6.
DLRO order says otherwise. Please see page 46.
My lord.
46 is that brief fact is that 0.12 acres out of 0.23 acres of plot in question, that is LR plot number 921, such and such was acquired,
yes,
by LA Purbo Medinipur Bhide LA case of 51-52, and 6 acres has been recorded in favor of the PWD in LR Khotiar number 3071, rest 5. So it comes 12 plus 6, 18, then 5.
My lord, rest 5, my lord, 6 and rest 5. It would be, my lord, 6 and rest 5 means only the brief fact.
So 18 has been acquired. 12 and 6.
12.
My lord, kindly. My lord, kindly.
12 and 6 is 18.
6 plus 0.6.
5.
My lord, kindly, my lord, comes to page
18 has
34.
been acquired, Mr. Mahato, please take
Right,
instruction.
12.
Right.
18 has been acquired.
My lord, kindly, my lord, comes to page 34 once. 34, my lord.
Because It says
18 and
18
5
has been
decibel.
acquired. So remaining is 5.
Only remaining is 5 in favor of the private.
That is why the DLRO says
that
if
would
there is
be-
any correction
Sir,
necessary.
if necessary, everything, my lord, will be done, inquiry will be held, demarcation will be made.
That is my whole contention, my lord. Let an opportunity be given to me, my lord, prior to
Already
prior to-
opportunity provided.
No opportunity provided to
They
me,
are
my
now
lord.
party.
My lord, my lord, kindly, my lord, comes to page 34 once, my lord. Page 34 once.
আরে এই তো নোটিশ সময়
Page
দিয়েছে
34, my lord, page 34A, my lord, is the legible copy.
Yes.
My lord, kindly sees, my lord, the last two plots, my lord, the column 921. 921, my lord, the last two plots. Plot number 921, area in acre is 0.2, 0.2, and my lord, the next page is another 0.2, 921. My lord, points, my lord, 6 decimal was, my lord, deed requisitioned prior to, my lord, the second acquisition process.
But what about the deed, my lord? Deed itself a vague deed.
Kindly, my lord,
Deed
let an
itself a
opportunity be given
forgery.
to me, my lord. An opportunity be given to me, my lord, for hearing.
Be inquired into.
By the placing of forgery deed, he is claiming the record of right.
My lord, he is, my lord, suppressing, my lord, the fact that my
Suppressing
name
the
is
fact of acquisition.
The petitioner
His
Yes.
I appear for the state.
Yes.
Lordship recalls, my lord, this is one of that matter where my lord, Mr. Roy was my lord, arguing on the last occasion.
Yes.
Long-term settlement, my lord. Long-term settlement matter, my lord, that.
Yes, yes, start. Yes.
My lord, we only know the facts, my lord, but Mr. Parthokitim Rai is only.
Where is Mr. Rai?
Only 10 minutes, my lord, he will be there. Thank you. 10 minutes, my lord, he will be there.
10 minutes.
15 minutes.
Then 15
But
minutes.
I'll tell you, Lordship, my lord,
Half an hour.
No,
perhaps
15 minutes.
3 p.m.
Much.
3 p.m.
Interest
3 p.m. not today. But that even, my lord, can it be not today? My lord,
Right.
my lord,
3 p.m. you have difficulty.
Yes, my lord.
3 p.m. you have difficulty. 4 p.m.
Very well. Very well.
4 p.m. Ask him to come at 4 p.m.
Nah.
Yes, yes.
Okay.
The last occasion it was heard by your mercy.
Yes, yes.
Report was directed to submitted.
This is the report.
একটা copy,
Our solvability is paid by the
একটা copy দেবেন।
and petitioner got it without. Without raising any objection, petitioner got it.
Yes, same thing as in the earlier matter, Mr. Mundu.
Yes, madam.
So, false statement on affidavit
Yes, sir.
that no compensation, no proceeding was initiated, what was declared. I think a proceeding has to be initiated.
No,
This time, in this manner, it cannot go
record
on.
of rights is not corrected.
Maybe you know when you have received the compensation or not.
No, no.
Maybe you are taking advantage of the wrong recording of the
No,
record
no,
of rights.
we are not, we actually not received any compensation.
See, my God.
Maybe but
Our-
award has been declared, this notification,
No, no, আমাদের নামে হয়েছে কি? Award আমাদের নামে হয়েছে?
What are you
পুলিশ
saying?
মন্ডল।
181, my lord, serial number.
Your serial number, everything has been given.
কমলেশ মন্ডল আপনাকে দিয়েছিলাম দিয়েছি তো দেখুন না
Kindly,
181
next date, kind of.
No next date.
Take instruction from.
No next date, no instruction. Your client knows
Because
everything.
it should not be allowed to be happened. I do not justify it, my lord. If it is happened, my lord,
What to justify?
I cannot justify.
Petitioner.
সত্যি জানি।
My lord, I am for the state, my lord.
You are for the state.
Yes, my lord.
Who is for the petitioner?
Earlier occasion, my lord, it has been heard, my lord, your lordship observed that
Earlier occasion there was a resolution.
fuel it is tribunal, my
So I have adjourned.
My lord,
And
fuel
appears for the petitioner at the time of. You also did not appear. Yes. Next.
30, I am for the petitioner, your lordship.
Private respondent.
I'm for the state respondent.
I'm for the respondent, sir.
Private respondent.
Yes, sir.
Lordship,
Kindly sort pass over, Lordship. He is on legs, court number.
Who is
8.
on legs?
Mr. Priyankar Ganguly, Lordship.
You are here. Yes. Yes.
Lordship, matter already been resolved between the parties, your lordship.
Already
There
been
is
resolved.
Lordship. There is a written instruction, your lordship.
The
My lord, in this matter, there is a limited interview order. Let it be extended because, my lord, I have another fixed matter at 3 p.m. My lord, it will, my lord, interview order be extended for limited period, my lord. Then let it be calls there.
What is this matter?
My lord, that Jivan Das Bajaj, that my lord, the
Why not settle?
my lord, practically, my lord, the lecture of the petitioner is, my lord, for 40 years.
When do you want to come back?
My lord, any day, my lord. Hold. I'm
Immediate? 2 p.m.
Yes,
4 p.m. on Friday. 4 p.m. on Friday.
I follow the practice of fixing at 4.
Yes,
4:30. Thereafter.
4 and
Not before 4.
and I have continued up to 4:45. That matter, my
You
lord.
can
That
fix at any time after 4. Not before 4.
Haldia municipality.
Fixing before 4.
Haldia municipality, my lord. Part of the judgment is everything.
Yes. The interim order is still which day?
Tomorrow. Till tomorrow.
Till tomorrow.
Yes.
And a couple. After hearing the learned advocates for the respective parties, the interim order is extended till the end of the month of May 2026 or until further orders, whichever is earlier. Let the matter retain its position in the list. Yes, next.
Retain its position.
As unreasoned an order can get. As unreasoned an order can get. Kindly looks at the impugned order.
Yes.
But
Yes,
kindly
Mr.
comes.
Mahato. Order of Mr. Mahato. Yes, Mr. Mahato.
Can't be his. But had can't be his.
Oh, he means he's representing
Yes,
his client means
yes.
seal.
And that too prima facie.
Yes, where page?
Page 22. The authorities have got into SMS generation also now.
Yes, Mr. Mahato. How can this order, you can support this order?
But one other thing, before your lordship goes into this, but your lordship, it fell from your lordship that your lordship sitting in a division bench had passed an order with regard to that, whether the urban land clearance, urban land clearance is required. But we have, as a condition for KMC sanction.
That goes against you?
No, no. We are relying on that. That was in connection with amalgamation.
Yes.
But still,
amalgamation and those.
Yes. But I would.
I think in courtroom number 11, Justice Talukdar.
Yes. Yes. But I'm carrying copies, my lord, for your lordship
Ashok
and my.
Banerjee appeared in that matter for the KMC, I
Yes,
think.
yes.
Yes.
But we are, if the bench has such memories, my lord, we are, my lord, at back foot.
Yes.
My lord, will kindly.
এই শান্তু আমাকে ডেকেছে যে আজকে
So there, I think KMC directed that this clearance certificate from the ULC.
ULC is required. That
But,
was
I
an
think
issue
what
with
is this issue? Here also same thing.
No, here we had to apply because that rule 4 is there. So, my lord, we had.
So this
Now,
judgment
my lord,
cannot be,
let there be first consideration, but because this is not the regent order, my lord,
so I'm directing to consider it afresh.
afresh.
only thing, my lord, if it so commences to your lordship, could I try my luck once? That, my lord, this kindly comes to page 15 of this order. Which page 15?
15 of which order?
Of the division bench judgment, my lord. 15 of the division bench judgment. But if I can borrow something, if I can.
Yes. Please give a copy to Mr. They have given, yes.
Not page 15, third paragraph.
Yes.
KMC is a creature of a statute. The authorities of the KMC has to perform the functions and duties as conferred upon them by the KMC Act 1980. Such authorities have no power to do anything unless such powers are conferred by the KMC Act. There is no provision in the KMC Act whereby a clearance certificate needs to be obtained from the competent authority under the ULCR Act 1976 for the purpose of amalgamation of premises. The KMC Act 1980 and ULCR 1976 are entirely independent of each other and they operate in their respective fields without any conflict. There is no corresponding provision in the ULCR Act making it obligatory for the competent authority appointed under the said Act to issue a no objection certificate or clearance certificate whenever sought for by any person for the purpose of, kindly juxtapose it with sanctioning of a building plan instead of amalgamation of the properties by KMC.
So here is, what is the issue here?
In our case, we had applied for sanctioning of a plan. There was a decree
Before
the Kolkata Municipal Corporation. They say that you have to obtain a NOC from urban land ceiling.
The rules provide
That is the rules.
I think the rules of the
Rule
KMC
rule
provide for
4.
that.
I said that rule 4 provides that.
But in this case, amalgamation, there was no such a thing. If the rules provide that, unless you challenge that rules, Mr. Gupta, you are bound by that rules.
But if your lordship kindly sees the rules once.
Because I think one decision was cited in that matter with regard to the sanction of a building plan, I
Yes.
think, if my memory serves me right.
My lord, I have to leave, my lord. 3 p.m., my lord, my matter has been fixed, and my lord, it cannot be adjourned.
No, so what was the issue? Mr. Gupta,
My
I'm
lord,
setting aside this.
they're without a reason.
My lord, kindly set this aside.
No, my lord,
Kindly
page 22, my lord, let the page 22,
only-
it is without reason.
But only
I'm not that wrong. Page 14. In Giridharilal Soni Supra, it was held that the KMC is not entitled to compel the petitioner to obtain a no objection, nor can it refuse a grant of sanction to the building plan in the absence of a no objection certificate.
from the industrial reconstruction.
Yes,
Department.
but in the case of Ganeshilal Supra, it's well said, judges.
But would your lordship kindly see the rule once, my lord? If I can.
I think let them reconsider this.
It is only applicable in case of a.
Envisages the ownership of any land.
Rule 4.4
The subject
is
matter of
only
today is
applicable.
the impugned order. আমাকে 3টের সময় মামলা ফিক্সড আছে, আমাকে যেতে হবে।
Then on another.
On another day, then my lord, on another day.
Want only merely setting aside and then it can be done today. If you want to argue, then
only one sentence. This rule is applicable only in case the size of the plot is above 500 meters. Mine is much below that.
Let them consider that.
Very well. Kindly makes it a time bound manner. Kindly makes it a time.
Yes, so this was ULC clearance application was rejected.
Yes.
So by a non-speaking order, I'm only setting aside directing them to reconsider.
To reconsider within a time bound manner. Otherwise, by everything
Yes,
is.
how much time? Mr. Mahato, within how much time? Mr. Mukherjee appearing for
10
whom?
weeks.
10 weeks, my lord, kindly.
For corporation.
10 weeks.
Kindly, 10 weeks.
10 weeks, my lord. No. At present, my lord,
Now this
10 weeks.
situation, Mr. Gupta,
Land ceiling will now,
the authorities.
All
officers are not
authorities are
there.
involved in the election.
That's the only difficulty. You are
election will
regularly
be
saying
over on 29th April.
Thereafter.
Election will be over on
They-
29th.
maybe they will come thereafter, 29th of April is 4 weeks.
4 weeks thereafter.
8 weeks, 8 weeks.
application. Otherwise, otherwise the application will not be entertained, Mr. Gupta, I'm telling you. Though this matter is not under group five. Take this. You can use it in another matter. This might help you in the amalgamation. Yes.
If that is an issue, then we can. Grateful.
Mr. Pan. So, let me see how far I can proceed in the month list. If all matters are taken up, then. Yes, then. File din. Yes.
My lord, my lord, first one can one is restoration, my lord. It was filed.
Restoration.
It was within time, my lord.
You have served upon the other
Yes,
side.
yes, service. State
Who
only.
who is appearing for the state?
Mr. Galib, I am told, my lord.
Mr. Galib, yes. What is the main matter?
Main matter, my lord, seeking, my lord, compensation, land compensation.
Seeking
compensation. Acquisition, my lord, first requisition and thereafter acquisition under the Act 2. My lord, nothing has been paid. Now they are further, my lord, taking further land. Out of 31 decimal, 16 decimal already taken. That is why, my lord, this writ petition was filed seeking compensation. And now, my lord, they are taking further land. Service, my lord. And my lord, affidavit opposition complete, my lord. And my lord, during pendency, my lord,
affidavit opposition filed. What is their stand?
Their stand, my lord. Their stand, my lord. They have acquisition, but no compensation has been paid. And they ওই রিপ্লাইটা কোথায় গেল এক্ষুনি পড়ছিলাম তো অপোজিশনটা যে পড়ছিলাম সেটা কোথায় রাখলি
Why so many applications?
My lord, in the meantime, my lord, petitioner number 5 died, my lord, so setting aside abatement and reply to there now. Their stand is, my lord, peculiar. They say, my lord, if the court passes order, they have to revive the proceeding under section.
Have you notified Mr. Galib?
Yes, yes, I have told.
Have you served Mr. Galib? No, yes or no?
Notice has been served, my lord, and along with
whom?
GPK.
When Mr. Galib is appearing,
learned
the learned advocate for the petitioner is directed to serve a the matter retains position. Yes, who is appearing? None appear. None appears for the
My lord, we have served for the second time, my lord. This is my affidavit of service, my lord. And for the petitioner, my lord.
No, served upon whom?
Upon the state respondents as well as to the
Who is
municipality.
appearing?
Because municipality is a pro forma respondent here. My lord, it is for the second time that we have served.
Municipality.
No, municipality is not the main party. It is a pro forma respondent. The state respondents are the main party.
What is this matter?
Urban development, my lord, there is an application and restoration also.
Yes.
My lord, it is our fault, my lord. At the very outset, I should confess this. Because although there was an advocate on record that was there, she got married. There was some communication gap. Thereafter, the petitioner contacted or did not, my chamber shifted. So all these factors are there.
97 days
My lord,
delay.
my lord. That's why my lord was pleased to serve, direct me to serve them again. That I have done, my lord. My lord, it
Who
is
is appearing? Who is the learned advocate?
no, my lord. From in fact, when this matter was dismissed for default, even on that date, also nobody appeared on behalf of the state. So, my lord, I have something to say on merits, my lord, if my lord permits. And this is a fault of my. I do not attribute any fault to the petitioners.
Yes, Mr. Singh. Can we appear for the state in this matter? Sir, please give him a copy.
My
lord. None appears for the petitioner. No accommodation has.
শোনো না
None appears for the petitioner. No accommodation has been.
My lord, this matter for the petitioner, my lord, I'm praying for a short passover, my lord.
No Passover business. Yes, please move, please. Yes. What is this?
This is the restoration.
What is the application for?
Restoration application.
Yes, what is the main matter?
আমাদের কপি সার্ভিস করে দেবো এই কপি সার্ভিস করেছে আমাদের Not actually, my lord. Restoration copy has not been served to me, my lord.
You have not served.
My lord, I don't have proper instructions, my lord, in this, my lord. Kindly.
What? Yes, are you opposing the prayer for restoration?
No, no.
Yes. What is the main matter?
Yeah, read petition, read petition. Unending. Read petition মানে তোমার এটা তোমার রিডটা কোথায় তাহলে কিছুই নেই আমার একটা কপি দাও
সেটা কপি সফট কপি এই যে
রিডটা কোথায়
রেস্টোরেশন দিয়েছে
না রিডের কপি
Yes. What is this?
my lord
মেইন ম্যাটার রেস্টোরেশন অ্যালাউ
রিড কি করে হতে পারে কাগজ দিয়ে সেকশন 5
রিডটা কোথায়
কাগজে কপি নেই
আমি সারা ধোকা যাবে বলছিস না
Yes, what is this matter?
my lord I find that the edit is not with me my lord what I recollect is my lord the writ petition is about my lord the police authorities taking over the land of the petitioners my lord without any
Yes.
appropriate my lord I would be beseeching my lord only restores and my lord kindly gives me 1 day my lord to come back my lord but I'm asking for tomorrow itself my lord kindly restores it my lord keeps the matter to
No peaceful business. No peaceful business. Yes, Mr. Adok, what is your instruction?
Actually, 2029 matters, mother. 19 matter. I have no mother on the read petition, mother.
I take instructions. The learned advocate appearing.
my lord I am for the petitioner my lord led by Mr. Tanmay Mukherjee
Yes, yes.
I for the petitioner led by Mr. Tanmay Mukherjee
Maybe. Yes, you are here. Yes, what is this matter?
my lord brief also is not with me
I will not allow any dismissal of
restoration
any applications. I'm telling you.
restoration application filed within 1 month my lord
Maybe.
at the
What's
time
the
of
main matter?
main matter is my lord compensation not granted
It is
utilizes
for the state. Have you served upon the state?
my lord state lastly appeared Mr. Devjit Mukherjee
Yes. Have you
for the
served the
state.
restoration application upon him?
I do not have the brief I don't know
An accommodation has been sought for on the ground of Mr. Mukherjee.
Expunging of the name of the respondent number 9, since well, the respondent number 9 prior to, died
An
prior
addition
to
of party of,
the legal heirs of respondent number 9.
yes.
Well, they, my lord, he died, my lord, prior to filing of this application, writ
What
application.
do you want here?
That can 1 is, my lord, for expunging of the name, and can 2 is, my lord, for addition of the parties. Yes, sir. The copy one.
You have submitted an application for allotment.
My lord, for allotment for rehabilitation, my lord, under the scheme.
Uh,
In,
done.
Well, after passing of the decree, my lord, after passing of the decree, my lord, prior to my lord, filing the appeal, my lord. And if it dies, my lord, we file an application, my lord, for it.
Banerjee, that's a different thing altogether. That's under 146. That's under 146. There is a specific provision in the Code of Civil Procedure.
My lord,
There are several judgments. If you file a suit with a dead person, suit is not maintainable, it's bad. You cannot add.
kindly, my lord, allows me to come back, my lord. Kindly allows me to come back, my lord. And I've the 23 application, sir. My lord, kindly allows me to come back, my lord, next week, my lord. On the next application day, my lord, kindly allows me to come back.
Yes, Mr. Dev, what do you say? You know? Where is your other side?
I am for the respondent number 6 to 7.
All come back to you. It's all about the cooperative bank. My lord, he had challenged the constitution of the board of directors being.
You have challenged.
Yes, being violative of the provisions contained in the Banking Regulation Act. And having regard to the law laid down by the Honorable Supreme Court in Panduran Chowdhury's case. When the Lordship was hearing this matter, the Lordship had sought for a quick affidavit reply from the bank. The Lordship was at that point of time taking up these matters in court number 6.
Yes.
Hearing.
Hearing of.
Yes. Till date, we could not get the matter heard out.
There is a bench for hearing
My
matters.
lord, your lordship will kindly take it up. May not be today, kindly take it up. Well, I tell you, lordship, my lord, given the term of the.
Do not have determination to take.
Yes, this is
2011 to 2015. Hearing of writ petitions.
Your lordship was having this determination till the cooperative, my lord. It a cooperative bench, though. Lordship is taking up cooperative matters. So, my lord, life is a full circle. We again come back to your lordship once again. My lord, only.
I'm 6 to 7. Bank.
I believe Mr. Siddhartha Banerjee.
Better if you go before a hearing.
No, my lord, we will do it before your lordship. My lord, we have tried our everything. This boy I mentioned, he has reduced. Look at him, my lord. He has reduced and mentioned over and over again. But couldn't get the matter.
Does not seem so what you are saying.
So, well, kindly post the matter on some
physical data.
Well, kindly keep it on some other day. We will. The bank is here. I think bank is here. Bank is.
Applications disposal is not a matter, Mr. Bonjumdar, if you want. But hearing is.
Keep it, man. Any day, subject to your lordship.
These motions that could not be reached.
I tell your lordship, it will all come back to your lordship because your lordship had heard this matter extensively. The matter was posted last order to bar korto, Josh Seven. Kindly take this order. Just once your lordship takes this order, it will all come back to your lordship. This was last heard on 22nd of March 2023. It is last order.
22nd of.
Kindly take my application. Thai ball.
No, 10th of February, I think, is the last order.
10th of February. কোথায় আছে? আমায় দেয়? দেখি? Yes. Your lordship was here.
Hearing bench, Mr. Majumdar.
We cannot get them at least. It's a fact. Because we don't have the requisite number of the courts. Your lordship understands that. 17 names are pending for reasons best known to, at least not known to us. Your lordship will find everything. Your lordship recorded everything in the order.
That I appreciate, but how much time it will take?
I will not take more than 20 minutes. And your lordship knows 20 minutes from me is 20 minutes. I'll give the relevant paragraphs of the judgments. I will distinguish the judgment cited by my learned friend, Mr. Banerjee, and I will conclude.
Which Mr. Banerjee?
Mr. Siddhartha Banerjee, তাই তো? Siddhartha Banerjee আর করছে না? কে করছে তাহলে? Oh, Mr. Obhinav Patra is appearing for the bank.
Where is he?
Well, he is at court number 29, engaged in a matter.
Where is the application?
Application, my lord, is can number 1
of 2020.
2025. ও অভিনব পাত্র অ্যাপিয়ার করছে, ওই সিদ্ধার্থ আর করছে না।
Next should be 3 application.
Your lordship was hearing the matter. That is why it was supposed to appear as continuing matter.
At that point of time,
that
long
point of
time passed.
I mean, 5 minutes. I will, we know, it will all come back to your lordship in a flash.
When to be taken up, that's the only difficult.
Whichever date, my lord. I
Operative matter, Mr.
my lord,
Majumdar, only
whichever
on Tuesdays.
whichever date suits your lordship, whichever date, whichever time, 4:15, 4:20, not 4:20, 4:15, we will come back to your lordship.
Uh, this is an application. Yes, call the next matter.
Great.
None appears for the petition at the time of
For the petition. This is application for substitution after setting aside.
what is the main matter?
The main matter, my lord, the refugee requirement exhibit one title deed in favor of the petitioner's husband, my lord. The area of the land is 3 kata something, my lord, instead of 4 kata. This is the main subject. We have challenged that in the media, my lord, petitioner is
We want the inquiry report to be supplied.
Yes, my lord. Inquiry report.
21st. Yes, Mr. Dey.
Yes, my lord. I have
Supply the inquiry report.
I have all reports are there.
You have got the copy of the inquiry report. Supply it and
one thing, my lord. So, fix it tomorrow, my lord.
what fix it? You wanted a inquiry report. He is supplying. What remains in the
দাঁড়াও না এত তাড়াহুড়ো করতে কেন এটা খুলতে হবে
what remains in the writ petition?
I wanted an inquiry report. Okay, listen.
You have got the inquiry report.
এটা না কাটা পর্যন্ত
অ্যাপ্লিকেশনটা ততক্ষণ অর্ডারটা রেকর্ড করে নিন ইজ অ্যান অ্যাপ্লিকেশন
Before, my lord, I beg to appear for the petition, my lord. My lord, I was praying for a not today in this matter. My lord, this application is only for restoration, my lord. But the difficulty is that, my lord, I don't have the affidavit of service ready with me right now. But the other side have been duly served, my lord. Matter was
is a defective one. Subject to my lord kind consideration, page my lord kindly see page 35. First one, state has not got the right title interest over the property. What happened, my lord? The fact is there. We are having so many lands. After coming into force of State Acquisition Act, we filed B form. That B form was not considered. Land vested to the state. We preferred title should declared should before the civil court. Title declared in our favor. After declaration of title, we made an application before the
substitutions. The lead
substitution.
petitioner died.
Sole
The lead
petitioner
petitioner
died.
died.
Sole petitioner died.
This is an application, non
I'm appealing for National Commission for Scheduled Caste.
Yes. What is this matter, Mr. Chakraborty?
My lord, this is, my lord, they are not following, my lord, central government regulations. My lord, the person concerned, my lord, the petitioner, my lord, bank, the petitioner, my lord, employees cooperative bank. They are not following, my lord. A complaint was registered before the commission.
Challenge in the writ petition.
They are, my lord, challenging, my lord, the order passed, my lord, by the National Commission. Lordship, kindly sees the prayer portion.
National Commission for
Schedule caste.
how can it be a group 1 matter?
My lord, probably irrespective of is the, my lord, I do not know, my lord, if there is any determination as per, my lord, year-wise determination, it cannot be, my lord, a group 1 matter.
My lord, I'm praying for not this week because she is led by my lord Mikasaran Bhattacharya. My lord, due to medical emergency is not appearing. My lord, kindly makes it not this week. My lord, she shall.
Cannot be a group 1 matter.
Lordship, kindly sees the prayer portion at page. Tends to, my lord, they are not following roster.
My lord, it was heard by the before the coordinate bench, my lord. It was heard before, my lord, by the coordinate benches, my lord. It is copy to clarity, my lord.
Has been sought for on the ground of the learned advocate.
I'm appearing on behalf of the petitioner.
Yes, it's the CAN application for the restoration, and this is the affidavit of.
CAN for restoration.
This is the affidavit of service.
Yes.
Lordship, in item number 547, Mr. Pulokesh Bajpayee will appear on behalf of the Union of India. Due to some personal difficulties, he could not come to the court. Kindly take up the matter on next week, Lordship.
Lordship may be permitted to intervene the matter.
Yes.
Lordship, on last occasion, the appearing counsel couldn't appear in this matter online, and
Lordship,
the
kindly.
juniors were there. For this reason, the matter was dismissed for default. And for this reason, Lordship, this is a restoration
Yes, why
application.
review? What is the ground of review?
Lordship, the ground of review is the review is upon the judgment passed by your Lordship.
What is the
For
ground of review?
The ground of review is, Lordship, there was the petitioner was terminated from the service and filed a writ petition in the year 2011, and your Lordship dismissed that writ petition. And the main ground of review is that the authority with whom the review petitioner got entangled as mentioned in the memo of charges, Lordship, there was a private hostility between the petitioner.
Cannot be a ground of review. Prefer an appeal.
Lordship may be permitted to intervene into the matter and for the petitioner. He is my junior.
Yes.
Lordship, actually, I found that the matter is the appeal in disguise. So it will be preferable that if your Lordships give me liberty to go for an appeal.
Thank you. Ashun,
let the matter be restored, Lordship. And liberty may be given.
This is an
My lord, one indulgence, my lord. I don't know, 5, my lord, 36, my lord. It is dismissed for default. I was, my lord, in another court.
File an
Mrs. My Lord, Anita Khetri is appearing, my Lord, in this matter. My Lord. She was out of session, my Lord. Kindly restore it because there was a restoration application, my Lord.
Please call the other side. Have you solved the other side?
In this matter?
That matter, that matter. Yes, call this matter.
My Lord, kindly, my Lord.
Who is for the other side? Please call him. Yes. Yes, yes. Who is appearing for the petitioner?
But the petitioner only state service, my lord, only
Lord,
other respondents not services, my lord.
Lordship,
Other respondents not
only
service.
one in
By paying for time, my lord.
Lordship,
Yes.
only one indulgence, Lordship. Actually, during pendency of this review petition, a delay occurred. Let that be
Delay I
condoned.
cannot condone. I cannot condone the delay. How can I condone the delay? You have to apply under the appropriate provision.
Okay.
Yes.
By
Yes,
paying
yes.
for time, my lord, other respondents not service, my lord.
You are for the
state, my lord.
You are for the state. Yes. What do you want?
By paying for time, my lord, other respondents not services, my lord. It is the change brief, my lord.
The learned advocate appearing for the
Forty-nine, my lord. It's my application, restoration application, my lord, dismissed for default.
What is the main matter?
The main matter is, my lord, is the petitioner purchased a property and, my lord, which subsequently he came to know that these land were acquired. He made an application for RTI, my lord, for housing scheme, my lord. Thereafter, he made to the housing department also RTI that was not utilized. I made a representation for consideration. If it is not utilized, then
it has been acquired.
RTI is RTI replies. One says that it's acquired for housing scheme. I have made an RTI application to housing department that has no say that has not been utilized.
Utilization and acquisition are different concepts altogether. If it has been acquired, how can it be released?
Housing scheme also ki
Even if not utilized,
it is not involved in any. It is not involved.
RTI says that it's not been involved in the any acquisition scheme, my lord.
Then there is no question of releasing.
No.
But I made a representation, my lord. Let that be considered, my lord.
Where?
But when
That will be RTI information.
no, document application go to document supplementary affidavit করতে চাইছি।
That is with that document, I want to make a supplementary affidavit. My kindly.
What document?
With that with RTI reply, my lord.
অ্যাপ্লিকেশনটা করেছি আপনি লেটার দিতে পারেন।
If my lord kindly sees
Yes,
that.
Mr. Tay, what is the instruction?
If representation at page 63, my lord, we have.
Already that matter was disposed of by
If kindly sees as a representation page 63, my lord. Let that representation be considered, my lord.
maybe considered.
So according to you, it has not been acquired.
No.
Yes.
If my lord kindly sees a order, similar order, my lord, it to them. Similar plot of land, my lord, I moved writ petition, my lord.
I'm not on a similar plot of land. I'm asking you whether it's acquired or not acquired.
According to
Similar, not similar, that I do not know.
according to the RTI, it is involved.
Yes, only that is what I'm asking you. Has it been acquired?
That is really involved in the acquisition proceedings. It is in the RTI report, my lord. It says involved in the acquisition proceeding.
But when for housing
The petitioner.
Engage in code number 16, my lord.
rest-
I am praying for not today.
Section 5 and restoration application.
What is the main matter?
The petitioner's land was acquired, but till date no compensation has been paid. The special land acquisition officer is rejecting the prayer of the petitioner, and thus that order is challenged in this petition.
Yes. What is wrong in this order? 11th of December 2024. Why are you looking at the door?
Sorry, Your
I'm asking you what's wrong in the input order. You are looking at the door. Not today. Next. Yes, yes.
From the left, agents of Messrs. Eastern Coalfields Limited, my lord, got it. From the bottom, 1, 2, 3, 4, 5, 6, 7, 8, 9 line from the bottom, from the middle portion, Messrs. Eastern Coalfields Limited, that no point of time I have sold the above mentioned plots to Messrs. Eastern Coalfields Limited. Neither they have taken no objection from me, and as such, they have no right to disturb my peaceful possession. However, those unknown persons have left the place with the assurance they would come back. Thereafter, Mrs. Eastern Coalfields Limited forcibly acquired the said land. Excavation works has started without having prior permission.
Who is for the state? Yes, Mr. Rai. Who is for the state?
The court fee
While
is
looking there, your advocate on record must be knowing who is for the state. Now he's looking at on his level.
the Eastern Coalfield is the authority. Allegation against the Eastern Coalfield Authority.
Eastern Coalfield is doing that. You have
But
made a
district
representation.
magistrate will
Yes, but
file the
the
report.
copy to was also
It's a
sent
correct
to the
You have
state.
the instructions with you.
Instruction আছে কি?
Hmm.
No, my lord. Instruction.
When can you file the report?
কত? 300? Well, so far, whether report in the form of an affidavit or affidavit in opposition, well,
Not affidavit in opposition. Only report.
report, well, 2 weeks. No, report should. 3 weeks, well, within 3 weeks.
Why 3 weeks? Within 2 weeks.
2 weeks corruption.
Uh,
Five to my land, the petitioner, my lord.
Yes.
My lord.
My lordship,
Restoration.
What is the main matter?
My lord, the land of the petitioner is occupied by the, my lord, West Bengal Mines and Minerals Department, my lord, without initiating any acquisition procedure.
my lordship, my senior learned advocate, Mr. Sanjay Shah, is not out of station. And so I'm praying for not this week.
Petitioner make representation on the 4th of June 2025, my lord. That was not. Yes, yes. Mr. Day is for the state, my lord.
Who is on lake? Rawlal Lake.
He's for the state, my lord. Affidavit, sir.
Yes, what do you say? Mr. Saha is not available today.
As per your lordship, any day, my lord, for me. But if the restoration be, my lord, No. Within time, it is filed within time.
Yes, madam, are you opposing the restoration application?
Sir, I have no bid.
All right, not today. Yes,
None.
next.
It is new.
It is written in its position. It retains.
May I please, Your Lordship, my lord, this is my application, my lord. This is relating to restoration application, my lord.
Yes, what is the main matter?
Main matter, my lord, the respondent number 6, my lord, the railway authority was making the railway underpass, my lord, without following any procedure of law, without, my lord, initiating any proceeding, my lord. Thereafter, the petitioner made representation before the, my lord, authority, my lord, additional district magistrate, my lord, why they are taking these steps without following any procedure of law under section 4, 6, or 11.
Who is for the railway authority?
My lord, I have served, my lord. I have served twice.
And I am appearing.
You are for the railways? Yes, what do you say?
No, copy when mine. I have only received the restoration application, main application.
My lord, I have served.
You have not received.
My lord, they have received the main application, both the, my lord, affidavit service was there.
This petition,
They have received on 8th September 2025, the DRM rate, how Shialda, my lord.
My lord, Mr. Sijip Chakraborty appearing also, my lord, led by Mr. Sijip Chakraborty.
Where is Mr. Chakraborty?
My instruction is that we also have not received the copy of the petition.
Petition you have not received. Please give them a copy.
My lord, Joe, I have, my lord, served, my lord, they have received all.
All right, I'm restoring this.
Yes,
the after hearing the learned advocate for the petitioner. The copy of the petition take a soft copy. Soft copy. Yes, call the next matter.
Affidavit. No, service. My lord, may I file the service?
My lord, I am for the petitioner. I am for the petition. An application for restoration, my lord.
Yes.
I have filed in time, my lord.
File in time.
Huh?
Yes.
Hey,
Yes, yes.
there again.
Remove the encroachment.
Illegal encroachment, my lord.
Yes. What do you say?
I have no restoration application copy. Eight. আমি এটা দেখেন
Yeah, on hearing.
The original writ petition can be disposed of, my lord, although this is a restoration application, very innocuous prayer, my lord. Kunta tuma.
What a fixed matter.
Number is 555.
We have fixed matter.
Where is Mr. Ra?
Held. Yes, Mr. Rai, when the matters are called on, you are not there.
দিয়েছি তোকে পাঠিয়ে দিচ্ছি
Judgment পাঠিয়ে দিন।
না না না, ওই ওটাই ওটা বলে বল।
Send me one judgment copy in the morning today.
Yes, he has not supplied the copies.
Only one judgment, but today morning he has given. I nothing else.
You are permitted to rely only that. No other judgment, Mr. Rai.
No other judgment which by learned friend rely but those I rely তাহলে তো হয়ে গেল
Those are already.
Yes.
এটা এখানে না রেখে
কি রে ল্যান্ডার্স ম্যানুয়াল
তোমার নোটটা দিয়ে দে একটু হার্ড কপি।
Now 49 and 52, these are the two provisions. একটা খুলতে চাই ইন্টারেস্ট
49.
Yes.
49 of which act?
Land West Bengal Land Reforms Act কি yes. So earlier occasion, my lord, I have submitted to your lordship that 49 presupposes the distribution of land in respect of the homestead and agriculture. Now, my lord, kindly consider West Bengal Land Reform rules which were framed 20B. Rules.
Manual you will also be relying upon.
Yes, because my lord, the posted cropped.
Rule 20B.
Yes, rules. 20 capital A,
20B.
not 20 capital A.
A, if your lordship, kindly before I want to draw your lordship 20B. As soon as the application for information received by the revenue officer, a land has been obtained by any person under subsection 1 of 49 by practicing fraud or misrepresentation or transfer of land has been made in contravention of the provision of 1A of the section 49. He shall have a case started, call for the connected records. Pause there for a moment. My lord, can you turn to now 20 capital A? Because why, my lord, I am submitting your lordship? These are the leases of a particular period 10 years, and that too for the commercial purpose. Settlement of lands which are at disposal of the state government may be made by the collector of the district land reforms officer, of the subdivision officer of the subdivision of the district in which the lands are situated. Such settlements shall be made on a permanent basis, and a person with whom the land is settled shall have, subject to the restriction imposed on transfer of such land by subsection 1A of section 49, all the rights and obligations of a riot as prescribed in the act and rules from thereunder. The area to be settled with the parcel shall be subject to the maximum of such area as together with the land already held by him as a riot, and half of the area cultivated by him as Borgather does not exceed 0.40 hectares. So, my lord, there are two restriction imposes. One is that it is for a particular purpose, a permanent tenure. Second is for that the restriction imposed that land will be settled with you, but your existing landholding capacity should not exceed 0.40 hectare. This is presupposedly, my lord, apropos to this, my lord, kindly consider section 49 for the agriculture and homestead. Now, my lord, can turn to section 52 of the Land Reforms Act. Huh? All lands too.
So you can take your seat, sir.
Yes,
It will take some time, I think.
চলবে
এই সবাই
Mr. Rai is the reason.
কন্টেম্প নেবে All lands to which this act applies shall be deemed to have been held under the state on which such terms and conditions has been prescribed. Any land belongs to state or land which is at the disposal of the government or held under the state by virtue of the provision of West Bengal Extraction Act 1953 or Act 4. Unless the state government otherwise directs by a general or special order be managed in a manner as prescribed by the collector of the district under whose jurisdiction land are situated, subject to the control of state government, particular determination of terms and conditions of the lease as may be specified in the lease deed and fixation under rent without premium. If the government is observing different sets of rules are necessary for the management of different classes of land for the different areas, it may make different sets of rules under this section. Now, my lord, can you turn to ইয়েটা নেই না ম্যানেজমেন্ট অফ এস্টেটস এর ডেফিনিশন এগুলো now if your lordship may kindly consider rule 28A
28A
A my lord got it
yes.
So 52.2, my lord, for the purpose of giving effect to 52.2, Rule 28A is the provision.
Yes.
Yeah. The matter I mentioned, it's 561. Your lordship took it up to 555. It will be my lord's pleasure to take it up tomorrow. Extremely urgent, otherwise I would not have, my lord, troubled your lordship.
The Chatterjee, my experience is very bad today.
I was waiting.
All the restoration applications have been dismissed today.
No,
Don't take a chance today.
No chance.
Don't take a chance.
I can do it today if I shall wait. If not, kindly takes it up tomorrow.
Yes. Yes. Yes.
Sorry for disturbing. Please carry.
Yes. Yes.
Now, if your lordship kindly takes up 28A. Without prejudice to the provision elsewhere contained in this rule, all lands and all interests therein belonging to the state government shall be managed and shall be deemed to have been managed by the collector of the district under whose jurisdiction the lands are situated in accordance with the West Bengal Land Reforms Manual 1991. Published by the Board of Revenue West Bengal, being the rules for the time being in force for the management of government lands, and it's subject to the direction as well as general or special order be issued from time to time by the state government in this behalf, provided the state government enters the management of lands belonging to it in any area, local body or authority constituted by the underlying law time being in force and condition. So these are the two things. Now, my lord, the West Bengal Land Reforms Manual, kindly consider the provisions. 52 is where the 52 is there.
Land Reforms Manual.
Yes, my lord. The rules, my lord, if your lordship may kindly turn to 233. No, 233. Chapter 15.
Chapter 15, yes.
My lord, got it. 215 rules. The settlement of non-agricultural purpose is provided for Rule 20A, Sub-Rule 6 of the West Bengal Land Reforms of 1965. Rule 20A, Sub-Rule 6, authorized collector district with prior approval of the Board of Revenue to settle the land in of any classification or description with the disposal of the state government with the person or group of persons, an organization or a statutory body for the town's condition, maybe by a general special order by the Board of Revenue. Next, the lands of non-agricultural purpose shall ordinarily be settled on long-term lease. Where the long-term settlement is not possible, either because of the land is not become sufficiently developed, pilot regulation note long-term lease shall be made without the prior permission action of the Board of Revenue. My lord Kali, I am pausing here. My lord, Board of Revenue. After that, settlement of non-agricultural purpose should be made under the registered lease from 1 to appendix standard forms of long-term and short-term lease, respectively. No variation should be made in prescribed forms without the sanction of the Board of Revenue. So, my lord, the mode which has been also been annexed with the West Bengal Land Reforms Manual, this is the forms on based on which this lease deeds
Sanction from the Board of Revenue.
Board of Revenue. Now, on a long-term settlement, I give the next to 2020. The collector shall identify the suitable plots of land for long-term settlement, keeping in view of the long-term.
The point which you are trying to.
Yes, my lord. Now, my lord, what is the point? That I prayed for commercial purpose for allotment of plot of land. This allotment of plot of land, long-term settlement. 30 years, more than 3 years is a long-term settlement. Now, my lord, two things. One is whether, my lord, it counts in the period of 49(2) or 52. There is no other provision on the West Bengal Land Reforms Act whether there is any mode where the settlement can be made. 49(2), my lord, will find this is restricted to the agriculture and homestead land. And 52(2).
But if you kindly come to this 28 which you are placing.
Yes, this is
28.
52(2).
Says 52(2). And
28
and 20A deals with 49.
49.
Now 20A6.
Rules. 20A6.
(20A6) relates to non-agricultural.
Settle a land of any classification.
Yes. Because
or description which the disposal of state government with a person or group of person.
Subsection 5 of 20A is very relevant. It says sub-rule 1 to 4 shall apply only to such lands as agriculture and homestead. 6 is a starts with a non-obstantly clause. Content elsewhere. So it's a residuary clause apart from agriculture and homestead. So it brings within its fold the commercial and non-agricultural purpose also.
Yes, any description.
Yes. So 20A6 deals with non-agricultural purpose also, and for that prior approval of the Board of Revenue. So it's not that only 49(2) specifies settlement of only agriculture and homestead.
But 49(2), my lord, can you consider what 49(2) once?
But the rules speaks of.
Whether the rules can enlarge the scope, because these rules, that is why, my lord, if your lordship can consider 49(2) once. (49). A and B, my lord. These are the classes of land which are mentioned therein. And upon the restriction that the person should not possess or have more than that quantity of land which is there, either in aggregate with the members of the family or others.
No, Mr. Rai, please kindly come to 4A5.
4A5.
49 4A5. 4A and 5. This deals with the other things.
49 4A5. 49.
But I do not mean to interrupt him, Lord. May I just indicate one very fundamental thing also? Well, the definition clause under the West Bengal land
Land
reforms,
includes everything.
it includes society interests also.
Yes, yes.
It is all covered.
Sariyati interest, Sariyati interest land.
But here, Mr. Rai, it's also non-agriculture and other things. Up to 4, it deals with agriculture and homestead. From 4A, it deals with the other aspects, agriculture, industrial, non-agricultural, everything commercial. That is why this refers to Rule 20A6.
Foregoing shall the state government or officer authorized by the behalf of the state government transfer.
Both 49 and 52 speak of any land. And my lord, the definition under subsection 7 of section 2 of the Land Reforms Act
of all description,
which includes society interest and any other land, my lord, everything has been.
It's not only agricultural, for other purpose as well.
The state government but kindly consider 49 4A once. Notwithstanding anything contained in the foregoing provisions, that means that except the agriculture and homestead land, foregoing provisions of this section, the state government or an officer authorized in this behalf by the state government may transfer or settle with a local body or an authority constituted or established by or under any law for the time being in force land which is at the disposal of the state government for such purpose and
such purpose and on such.
So, the purpose is to whom? With whom? Now can you consider?
Yes.
State government may transfer to or settle with a local body or an authority constituted or established by or under any law for the time being in force land which is at the disposal of the state government.
So according to you, it has to be
statutory body,
local body or an authority.
Yes, because apropos to this, Kali considered two provisions under the West Bengal Panchayat Act and West Bengal Municipal Act. West Bengal Panchayat Act subject to action section 173 postulates. As soon as the Panchayat is created, all the interests of the state government vest with the Panchayat, including all the Sariyati interest. And that is why, my lord, if your lordship kindly consider it, that is why, my lord, a question cropped up for consideration before this honorable court. Whether the Panchayat is bound to call for a tender for settlement of the ferrygut under the West Bengal, considering the provisions of West Bengal Land Reforms Manual or not. There the honorable division bench held. No, Panchayat has his own settlement procedure. They are not bound by the West Bengal Land Reforms Manual. ধরে বসে আছে অঙ্ক না এটা পূর্বে হয়েছিল যশোর পূর্ব
20A.
Yes, my lord.
6. What does
49.
A6.
Rules 20A6. Yes.
According to you, Mr. Rai,
6 cannot override the parent provision of the rule act itself.
Then you have to challenge this because, but it uses the expression
person, a person. That is why.
For persons also.
Yes.
Expression of persons, then institution.
Those are there. Well,
So person and group of person, if you say that, then you have to
Whether
challenge
the rules can enlarge the
You
parent.
have to challenge the rules then. Unless you challenge the rules, Mr. Rai, it's difficult.
Section 49, my lord, if that be so, my lord, then my lord can consider section 52.
But this is what is troubling, because it says 20A6. 20A6, as you are right, 49 does not speak of 49 to from 4A5. It speaks of
Only
local.
6. A6. That is why, my lord,
Yes, A6 is what is troubling.
troubling. But if you logically consider this rule is trying framed to giving effect to the provision of section 49. So if the
Then you have to challenge its. You have to challenge the virus of the rules, then, Mr. Rai. Otherwise,
if you logically consider 28A,
no, Mr. Rai, if you take a 5, I think it clarifies. Because there are two non-obstante provisions. One, 4A, you are right. That is for local body and those authority constituted established by any law for the time being. But 5, notwithstanding anything where a state government is satisfied that it is necessary so to do for a public purpose or for establishment, maintenance or preservation of any educational research or industry, comma, settlement for any period of any land may be made with any person or institution. So if it is for an industrial purpose, then also any person comes.
provided the object, the object, if you logically for what purpose it will be going to.
Industry has been defined.
Yes.
Person has also been defined. Person includes individual, firm, company, association, body of individuals, whether incorporated or no. Explanation 2 defines industry, tea garden, mill, factory, workshop also.
Yes.
Everything.
That is why whether the for the purpose of commercial activity, it is for personal.
Commercial also.
Whether it counts in the purpose of commercial activities. I want to open a godown. I applied for long-term settlement. Whether the court is, whether this act provides any provision for such settlement.
It is an inclusive definition, Mr. Rai.
Which include that is why
it's an inclusive, it's not exhaustive.
That is why, my lord, if that be so, then my lord,
inclusive, not exhaustive.
If that be so, my lord, then why, if you logically takes up in that the manner 28A.
28A.
Yes, my lord.
Yes.
Without prejudice to the provisions elsewhere contained in these rules, all lands and all interests therein belonging to the state government shall be managed and shall be deemed to have been managed by the collector of the district under whose jurisdiction the lands are situated in accordance with the West Bengal Land Reforms Manual 1991. Published by the Board of Revenue, West Bengal, being the rules for the time being in force for management of government land and estates subject to such direction. If this be the procedure to be followed, then my lord, what is the rules framed under 28?
Yeah, also speaks of it.
Then my lord, kindly consider the chapter 14 of the original Land Reforms Manual.
14 and 15 here.
Yes,
it carves out an exceptions for agricultural land and non-agricultural.
Yes,
here it has been separated.
Yes.
Here it has been separated, but Act does not.
Then my lord, kindly consider
it is also separate two portions of section 49.
Then my lord, if you are 28B, 28A.
Yes, 28A says
all management,
all lands and all interests belonging to the state.
Pause there for a moment, my lord. There is no inclusive of everything.
This is management.
Yes, this is the management settlement.
In accordance with that.
Yes, land reforms manual. Management into settlement, if that be so. 49 says settlement, my lord Kaligos.
Settlement and management.
Yes. By way of settlement, I can manage. By way of settlement, I can manage.
But then why it is two purpose?
Yes. That is why my lord can turn to West Bengal land reforms manual.
All right, huh? Let me do some homework. I think I have to also because so according to you,
rules have been framed under the Act is for
rules have been framed under the Act
and for specific purpose.
Specific purpose, no doubt with regard to that. But
judgment of the
section 6 that is
now on a section if like 20 S6, my lord is subject is 20 S6. If that be so, my lord,
with the 49.6 also.
49.6?
49.5, I think. 49.5.
49.5 is
4A 5 that provides so.
And my lord kindly consider 28A. If that be so,
what is the decision you are trying to rely upon?
ওই এটা দে না যেটা আজকে সকালে দিলাম তোকে
আমার কাছে প্রিন্ট আউট নেই আমার তো এর মধ্যে ধরা
What is that?
আচ্ছা আমি পড়ছি আমি একটা জায়গা থেকে যশোর
আমি বার করে দেবো
ওই যেটা আলিপুর জু
বার করো
in Alipur Zoo that ITC intended to make construct the hotel. What is the land reforms manual? What will the effect and to what extent it can be gone into? That your lordship will find. Judgment.
Is the division bench judgment?
It is on the Supreme Court.
Supreme Court.
The only judgment which.
What does it say?
That said that this management of land does not come for the purpose of settlement a particular person, because it is the concept of the government is that to by way of tender. যদি না ভুল বলে থাকি দেখি ডিস্ট্রিবিউট তো করবি আমি যেটা ফ্যাক্ট বলছি সেটা বল না
Please give me the reference.
Yes.
I'll give the reference is AIR 1987 Supreme Court 1109 and 1987 Volume 2 SCC 295.
1987
Volume 2 SCC 295.
95. All right, let me.
Yes.
কোন প্যারাটা দেখাচ্ছিল
তো দেন দেন শুরু করলো
আসুন
as to discretion of the executive certain certain principle to be observed.
40.
Owned or public owned property is not to be dealt with at the absolute discretion of the executive. Certain prospects and principles have to be observed. Public interest is the paramount consideration. One of the matters of securing the public interest when it is considered
Doctor,
necessary.
do you have a copy of that judgment?
But I also have the hard soft copy.
Yes, বেড়ে গেছে 40 বেড়ে গেছে
Give me the soft copy.
Yes.
এই জায়গাতে
তুমি
প্যারা 40
আরেকটা বার কর
কি আছে হ্যাঁ
থ্যাংক ইউ
আমি আর 40 সহ্য হয় না
প্যারাগুলো নোট কর প্যারা 40 লিখে রাখ
প্যারাগ্রাফ 40 onwards
No, where does it deal with the manual?
Manual, yes. Madam, can you turn to 32?
Let 32.
32.
Therefore, the manual has been diluted subject to pressure. In that sense, দেখো স্ট্যাটুরি ফেভার দিচ্ছে
Talking about the earlier manual.
Yes, that only the
Anyway.
settlement of Sariyat interest has been changed. So, but the others, there is no change. In 281, 276 onwards, up to 281. The Jolkor, Folkor, and Bilkor.
But it does not deal with that effect of.
It is there. I'll place before your lordship. If that be so, why not kindly consider? Here is the very specific provision: the state property can be settled by way of auction. Then whether this private negotiation is permissible or not. There it held, my lord. Like similar volumes goes on whatever name published by the boards of revenue, states of West Bengal, land management manual. Also is compendium, statutes and
which paragraph?
Paragraph 32, my lord.
32.
What
Yes, yes, yes.
What authority of Board of Revenue West Bengal, like similar volumes going by of whatever name published by the Board of Revenue of the states, the West Bengal Land Management Manual also is compendium of statutes and rules framed either by the government or by the Board of Revenue pursuant to statutory power conferred on them. 2. Order issued by the government from time to time. 3. Orders, circular, instruction and memoranda issued by the Board of Revenue from time to time. All these are arranged in such a manner that reference to them by officials of the revenue hierarchy is easy. Statutes and statutory orders have no doubt to be obeyed. It does not mean that other orders, instructions. So there were two sections there. That is precisely my argument before your lordship. Up to chapter 13, my lord will find there is a reference to the section. Chapter 14 refers to the section 49 in the manual. Also the 49(2) and 52 has been considered.
Yes.
আবার দেখবে 4-5টা বাজে তো 5টা বাজে তো খিদে পেয়ে গেছে আর
Mr. Raj.
complete my argument.
My lord, one indulgence, my lord, item number 536, my lord, I mentioned before your losses that matter has been. My lord, I called my lord, Mr. Devapratim Chatterjee and also Niloth Chatterjee, both have not come. Devapratim Chatterjee assured me that I am come. 536, my lord, kindly.
536 টাকে ওই বিজনেস ফরটা রিকল করে দিন, হ্যাঁ বিজনেস ফর ডিফল্ট আছে বলতে 536 টা ওটা।
I'm grateful, my lord.